your attention. God save the United States and this honorable court. This honorable court is now in session. Please come to order.
Thank you.
Please be seated and come to order.
Good morning, and I'm going to say welcome back. I'm very happy to say we're starting today at the Court of Appeals to resume in-person oral arguments here in the historic courthouse. I will note that the court's COVID safety protocols, including the wearing of masks in the courtroom and the public areas of the court, do remain in effect for all persons present in the courtroom, with the qualification, some of you may have been astute enough to notice it as we sit here on the bench, with the qualification that the masking requirement is relaxed for appellate counsel at the podium and the judges during the oral argument. With that, we will proceed. We have 3 cases on the calendar this morning. The first case we will call is Roberto de Carvalho versus OSPWEST LLC. Counsel?
Good morning, Your Honors, and may it please the Court. My name is Jamie Long. I'm a lawyer with the Legal Aid Society of D.C., and I represent appellee cooperative members Roberto and Vania de Carvalho, Selena Ochoa, Moises Nunez, and Dora Martinez. I'd like to reserve 2 minutes for rebuttal, and I'd like to thank this Court for allowing this matter to be heard first this morning to accommodate the fact that we have simultaneous interpretation in the courtroom for some of the appellants. The cooperative members have rights under the governing agreements of the cooperative that they live in. These rights are critically important because they protect the members' rights to occupy their homes. The members moved to intervene below to oppose the motion to expand the receiver's power, which would limit their rights, and they must have the ability to participate in the proceedings that threaten those rights.
So, Ms. Long, sorry to interrupt you so early on, but it seems like the Superior Court made a pretty fundamental error in that it said that there was no prejudice to your clients because it was going to decline to expand the receiver's powers, but then just a page or 2 before it had expanded those powers. So that seems to me to be a pretty obvious error, and I'm curious, why did you not move for reconsideration to put that pretty obvious error back before the judge to allow him to correct it?
So the reason the members appealed, that is, as you noted, an obvious error and I think a very clear abuse of discretion. It was not the only one. The judge also misapplied the other timeliness factors as it analyzed them with respect to the members. And so the members felt the best course of action was to seek this court's review, both of finding that it was an abuse of discretion to find their motion to intervene untimely, but also that the record is clear that all intervention factors necessitate a finding of intervention here.
And if I may ask another kind of threshold question, it seems like your motion to intervene had its own, you wanted to file a complaint, you had a lot of causes of action. On appeal, you seem to have narrowed, at least in your opening brief, to just this question of opposing expanded receivership. But then in your, and the appellees say, well, you've essentially narrowed the case to just that, and you have a footnote in your reply brief that maybe tries to preserve something else. And so do you think that the only issue that is before us is whether it's appropriate to allow you to intervene to oppose the expanded receiver powers, or are you thinking that if we allow intervention or we remand with instructions to consider intervention, all of the other issues would be back on the table?
So the answer is yes to both of your questions, that the issue before this court is whether they should be permitted to intervene to oppose the expansion of the receiver's powers. That was the reason for them intervening when they did, and so that is what was focused on in the briefs before this court. They did also, in compliance with Rule 24, include a pleading with their motion to intervene that did raise other claims that they believe they should be permitted to raise below. But the trial court's decision here did not take any issue with the pleading or the scope of any claims that were raised there. If the other parties or the court below feels that the scope of intervention should be limited, that is something the court below can do in its discretion, but it's not the issue before this court, which is just whether they should be permitted to intervene to oppose the expansion of the receiver's powers. And I think the answer to that question is clearly yes.
So on the question of whether they should be permitted to intervene, I take it you're asking us to address all the considerations that the trial court should address under Rule 24, or only the one that the trial court clearly erred on?
So yes, the members are requesting that this court reach all the factors. The trial court below only addressed timeliness. At a minimum, this court should reverse on those grounds, but the record is sufficiently clear that this court can look at all of the intervention factors, can also look at interest, impairment, adequacy of representation.
Do you think it's clear enough that is the remedy you want to order the judge to grant the motion to intervene? And why are what are we going to be doing when we're looking at all these other factors? Is it not the case that they're primarily, ultimately discretionary calls on the part of the judge? And this is another argument you're making going the other way, that, how can we reach those issues? Or do you just want us to sort of opine on them and take a look at them and prevent future error? Or what kind of remedy are you looking for?
So the reason the members believe that it would be appropriate for this court to reverse and order intervention, but it would be inappropriate to affirm by reaching other factors, is because the record is sufficiently clear that there is only one permissible outcome. Any other outcome would be an abuse of discretion. So given the fact that the record is sufficiently clear, the most efficient thing would be for this court to order intervention rather than remand for the lower court to make the only
And do you
permissible.
think that just primarily because, it's tied up in the error that the judge made on the prejudice question, but that you think that that is clear and that particular consideration is such a strong and often dispositive one? Because on some of the other factors, don't you think they might be a little muddier, or at least arguably muddier?
I think the members disagree that they're any muddier. I think it's very clear that the motion to expand is infringing on the members' rights. Decisions about their rights are being made because of the motion to expand in this case. And if those decisions are going to be made, they should have a seat at the table. They should be able to participate in and influence the decision that the judge makes with respect to the receivership order. And I think that's clear both looking at the timeliness factor and looking at the three other.
Is it your view that the district court at least touched the bases on all four of the factors, or are you thinking that the court only reached timeliness, but we can kind of sua sponte reach the others?
I believe that the court only explicitly touched on timeliness. Analysis, I think, of the prejudice timeliness factor sort of necessarily overlaps with the interest and impairment analysis as well. So I don't think that the court explicitly addressed any of the non-timeliness factors, but the members' motion below, I think, created a sufficient record that it is clear that all of the factors are satisfied.
One of the arguments your opponents make goes to the prejudice. They basically argue that no rights of tenants are being decided in this determination before the judge now whether to expand the receiver's powers, and that the tenants' rights to the rights that the tenants have to protect can be protected in the event the receiver seeks to evict them. How do you respond to that?
It's not correct that the members' rights are not being infringed upon in the expanded receivership order. The motion to expand requested, and it was granted, giving the receiver power to terminate cooperative memberships in a way that the cooperative itself would never have the right to do. So it was requesting power to give the receiver power to do things that the cooperative itself would never have the ability to do, and that
If the
is,
receiver did that, if the receiver tried to do that, in other words, not simply stand in the shoes of the cooperative, but exercise powers the cooperative you say doesn't have, at that time, would the tenants who are affected be able to raise all the challenges that they might want to raise?
so if a subsequent eviction action was filed by the receiver against members pursuant to these expanded powers, our position would certainly be that the members would be able to attempt in those cases to raise as a defense that the receivership order is unlawfully broad.
See, if that's true, one thing that I suppose gives me a little concern is that if we allow intervention now, if we or the trial court allows intervention now, the tenants would be able to raise all these arguments at the intervention phase, and then a lot of them would have to be raised again in the event there were activities by the receiver, assuming the receiver's powers are expanded. And I wonder if that's what we're talking about here, and if so, whether that's an efficient allocation of resources.
I think the counter argument on efficiency is that there are many members that are affected by what the receivership order gives the receiver the power to do, and allowing the members to participate in that decision in the first instance in this case would allow that decision to be made most efficiently in one setting where everyone is present. And I would also note that in those subsequent eviction actions, while I did say that our position would certainly be the members would have the right to raise opposition to the expanded receivership power in subsequent separate cases, I think it is undeniably true that judges in separate cases would be extremely unlikely to decide that the receivership order in this case was unlawful. And so we would certainly say they could raise arguments in subsequent eviction cases, but I think they would be much less likely to prevail in those cases than if they were permitted in this case to raise their opposition in the first instance.
So I understand that there are some eviction proceedings ongoing and two that have made their way to our court. Are your friends on the other side raising the expanded receivership powers to try and kind of get around some of the holdings against them in these earlier cases?
So in the earlier cases, including the ones that are on appeal before this court as well, those all predated the expanded receivership power. And so in those cases, the parties disagree on how to interpret the bylaws, on how the termination procedure should be interpreted, but everyone is operating under the assumption that the receiver cannot go beyond what the bylaws say. There have not been subsequent eviction cases filed since the expanded receivership order was entered, but it was very clear in the motion to expand that the purpose of it was to allow them to file subsequent eviction cases, so I don't think it is a question that is what's coming.
So just to clarify, and this may be actually a better question for your friends on the other side, in your view, let's say we endorse this lack of intervention, then you have this expanded receivership order. Could they then seek to take advantage of that under some kind of preclusion, or do you think they would need to bring new eviction suits under their expanded powers, kind of start the clock all over again? And just to sort of explain why I'm asking, Judge Glickman has pointed out you might have subsequent opportunities to challenge or raise objection to the receivership order, and I'm just wondering, is that actually true? Because if it's going to be resolved somehow in cases that are currently pending on appeal, or if we're wrapped up in this kind of sort of Venn diagram of cases, does that potentially deprive your clients of the ability to full-throatedly mount their defense?
Our understanding is that subsequent separate eviction cases would need to be brought, but as I mentioned a few moments ago, just because the members could raise opposition to the expanded powers in those cases does not mean that it is giving them the same opportunity as it would if they were permitted to intervene in this case. As I mentioned, I think subsequent cases with different judges would be very hesitant to collaterally attack the receivership order that's entered in this case. And so the members should be permitted to participate in this discretionary and equitable decision that the judge is making in this case.
And back to the timeliness question, what is the date by which you think we should measure timeliness? It seems like there are a few different points along the spectrum.
Yes, so that is another way that the trial court's decision abused its discretion. It measured the length of delay from the time that the members may have learned of the case in general. The law is clear that it should be measured to the time when their interest in the case became apparent. The reason for their intervention is clear from their motion. It is to oppose the motion to expand, and it did file its motion to intervene within 14 days of that motion. I don't think anyone has suggested that 14 days is an unreasonable length of delay. I would also note that with respect to another motion to intervene that was decided in the same order as this one, the judge actually found that even applying the wrong standard going back to when they learned of the case, the delay was substantial but not fatal.
You're talking about the condominium association?
That's correct.
Is there a basis for distinguishing his view of that, the prejudice and the timing in that case from this one, or do you see it as identical?
That the condo association's motion was filed about a month before the members.
Mm-hmm.
That's the only possible basis I could think of, but I don't think that a month is sufficient to change the analysis. And to be clear, the correct measurement is from when they learned of their interest, which was when the motion to expand was filed.
But when you say the correct measure is when they learned of their interest, your friends, to borrow Judge Alicon's term, which I like, on the other side would suggest there was an interest sooner, or they have different arguments about why there were reasons to get in earlier, and that seemed to be a concern of the trial judge, that your clients did not explain why they didn't get in earlier. Why is that not an issue for you?
I would first note that the interest of the condo association, I think while it is all wrapped up in the same property, is very different than what the members' interest is. So I think taking the proper standard of the length of delay from when their interest became apparent, it's kind of different comparing them between the two. But regardless of that fact, it's also clear from the law that even if there's an argument that a party should have intervened sooner, though I don't think that's the case here, but even if it were, the law is clear that the court should still consider whether there was any prejudice to the existing parties of any delay, and here there's simply no prejudice.
And can you tell me that, I think that comes from that DC Circuit case, Roan, which actually goes further than I think what you said and deems the prejudice as a factor that can be dispositive, or that is the most important. Is that the law here? Do we have cases saying the same thing?
I did not see a case from this court that said the same thing, but it is certainly the case that the Rule 24 in this court is the same as the federal rule, and that analysis in federal courts is applicable and persuasive here.
So I don't think you made this argument below, but I'm wondering if timeliness actually runs from the time that you learned that the co-op was not going to be opposing the expanded receivership, because that's when your interest arguably diverted from that of the parties in the case.
Yes, so I don't think that our position is that their interest runs at all from when the co-op decided not to intervene. If it were, I think that would mean that they intervened even sooner, because the deadline for the co-op to oppose would have been, I believe, 14 days, which is also when the members moved to intervene. But that also goes to one of the intervention factors that the court did not reach, adequacy of representation. And here, the cooperative does not adequately represent the members' interests. They have a financial interest in satisfying their debt and selling units vacant at market prices. They have filed eviction cases against the members in the past. So I don't think the members' interest is not really tied to what the cooperative does, because the cooperative does not adequately represent their interests.
And that leads me to sort of another curious aspect of the lower court's order. So the court grants the expanded receivership as unopposed, despite the fact you were out there trying to oppose. And so what do you make of that?
Yes, so I think that that fact reinforces the prejudice and impairment to the members of their inability to intervene. The court did clearly grant it as unopposed. There's nothing to indicate that the court grappled with any of the issues that the members raised. And so that fact further bolsters that they must be permitted to intervene here.
Can you tell me the error that the court seemed to make in saying, you know, you're not prejudiced because I'm not going to grant this motion to expand the powers, and then going on to grant that motion? It's so jarring that it seems like there's something, I'm missing something here. Do you have a theory? And you know, your opponents refer to it as dicta and downplay the significance of it. And I might see that if it were just the first reference, where you might think, is he just referring to the pandemic limitations or something like that? But what is your theory about how that order came to be so kind of self-contradictory?
My totally, to be honest, speculative theory is that there was maybe a prior version of the order where decisions on the motions came out in a different way, and it was not kind of thoroughly revised when that changed. But that fact, I think, makes clear that the court is kind of necessarily implying that if it had granted the motion to expand, which it in fact did, that does prejudice the members. And so I don't know for sure why that is, but I think that it further reinforces that the court agrees that there would be prejudice.
But even in that way, the order doesn't make sense, because you'd still need to address intervention first, which clearly the court was aware of for one of the would-be interveners. So it is very befuddling, but you don't have any coherent way to resolve it?
I don't believe so, I'm sorry. But I think from looking at the factors that the court looked at, it is clear that on all the factors that it reached, it abused its discretion.
Well, let us hear from counsel for your opponents, and you ask for a couple of minutes rebuttal, and you'll have it.
Thank you.
Good morning. Pleasure to be back in court, although not a pleasure to navigate traffic and to park. Took me twice as long as I expected, but fortunately I left just enough time. Mr. Lamb and I are going to be splitting our time roughly evenly, so I'll take 7 minutes, which will cause me to jump through things. But the thing I want to seize upon immediately is that it's absolutely...
Excuse me, could I just interrupt you? I don't think you've identified yourself
You're
for the
correct.
record, and I'd like you to do that.
Matthew Moore here on behalf of the current lender, was previously, I think, Lapis, but it's OSPWEST that was allowed to substitute for the original plaintiff in the underlying case. So obviously I prepared an outline for my discussion, but I think the most important point, based upon your questions and based upon the assertions of my friends to the right, they say that the first time they recognized they were prejudiced, or should have recognized, was the motion to amend.
So before you get into that, do you agree that the court's order is incoherent in that it says that it is going to deny the expanded receiver powers, and that's a basis for not finding prejudice?
I do not agree. I agree that it is just a harmless error, unintentional error, and that if we go through all the factors, which I will gladly do in 6 minutes after I make my first major point that shows the fallaciousness of the appellant's argument as to the timeliness of their intervention, I will address.
But you agree it's error, you just think it's harmless error?
I think it.
'Cause your
I don't
brief
think
doesn't
he
even
meant.
address-
I don't think Judge Rigsby meant to say what he did in that order. I think he analyzed all the factors, all the questions you are here today. The appellants don't have any stake in this fight. This is a contract, a loan between my client and the cooperative.
But do you agree that, that case law has said prejudice is, you know, perhaps the most important, often dispositive factor in the timeliness analysis. And, you know, you focus very much on the time it took to, you
And
know,
I've got
get
other-
involved. And I'm curious whether, you know, a couple questions. One is, what is your authority for making that so dispositive? And why shouldn't we care about the judge's actual words, which seem to be the only thing he's really saying about prejudice?
Well, you still have to go through all the factors. That's why you should care. And I think you should, the factors will lead you to believe that would be an egregious intervention here to allow someone or members who have no ownership interest in any piece of property. They own it, they have an ownership interest in the cooperative.
But can I ask you, what is your view of the argument that it's not really appropriate for this court to, you know, rule on these discretionary factors that could, you know, the judge himself might reasonably go one way or another on them, and all we know is he said something that we can't quite understand on a factor that appears to be kind of significant. Now, I understand your point that if you look at all these factors, you have arguments for how they all cut in your favor, but how do we do that? You know, just what is your response to this argument that these are really discretionary factors unless we look at them and think there's really no other outcome?
There is no other outcome, and Mr. Lamb cited case law that the Court of Appeals can look, the underlying court's order can be justified by facts or arguments not relied upon by the underlying court. I don't have that in front of me.
Well, you know, it
Mr. Lamb.
seems like a funny situation we're in. The court makes a discretionary decision that is supposed to consider a variety of discretionary factors that call for judgment and fact-finding and all the rest. And what we have is an order, and one side says we can reverse because it's clear as a matter of law what the answers to all those discretionary factors is. And the other side says, well, no, it's clear we should affirm because it's clear what the answers to all those other discretionary factors should be. And what we have, as I say, is an order that doesn't really address all those discretionary factors in a particularly thorough way, and addresses one of them, one of the most important, if not the most important, in a way that we all recognize
And
is mistaken. This leads me to think that, you know, our review is limited, and that what we do is we say, well, did the judge abuse his discretion, which is to say exercise discretion erroneously in a way that makes a difference. That seems like a pretty easy thing to say, because one of the factors the judge clearly said he relied on was one that we all agree was mistaken. And we should not try to substitute our exercise of discretion for the judge's exercise on remand with regard to that fact, with regard to all the other important factors.
The appropriate thing as the court pointed out in its questioning would have been a motion for reconsideration if they thought the judge didn't properly consider the factors. It's not to send this all back over again and decide all of the rationale is there for this court.
We don't normally, that's true, the question, there could have been a motion, I suppose, but we don't normally reject an appeal because no motion for reconsideration was filed.
I understand. I don't think the judge's statement was wrong, and that's what I wanted to get to in my first point in my less than 2 minutes left. The judge did not, the order expanding the powers didn't really expand the receivership's powers. Judge Rigsby was not wrong. The judge just really, the one thing they're complaining about primarily is that the board had to vote on the cooperative in certain instances, which is contested, which instances the board has to decide those. We don't believe the ones we've been proceeding under and have been the subject of 2 other appeals are ones that had to go before the cooperative board. So the only thing that's been changed is alleged procedural rights. And the point that I've been hoping to make for 6 minutes is that the original order appointing a receiver in May of 2019 clearly took away a procedural right that they had. That, according to my friends over here, would be the time when their interest first became apparent. Because in that original May order, if I can find it, the Longate Associates LLC is authorized to raise carrying charges in excess of 10% to allow the co-op to operate a break-even cash flow. That right to exceed 10% can only go by the board. Ms. Long, by her own statements, should have intervened the moment they saw this order, the moment they saw the motion to intervene that I believe was filed as early as December of 2018.
But the
That is
cooperative-
getting close to 3 years, and the prejudice is severe.
No,
We have-
excuse me, the cooperative at that point was adequately representing
They're
their
adequately
interests.
representing now.
Well, they didn't oppose this and was granted on the basis of being unopposed.
That's not a reason to allow them to intervene. They filed a motion to dismiss the case at the get-go. They filed an opposition to the order, emergency order to oppose the receiver. They have filed an opposition to the motion for the receiver to be allowed to foreclose on all the units. And ironically, in pages 3 and 4 of the brief, Ms. Long says of her original appellate brief, I don't understand why they didn't file a foreclosure action to begin with. And now that we're filing a motion for leave to file to foreclose, wait a second, our rights are being prejudiced, you can't foreclose. They just don't want us to proceed on our contractually given rights. Nothing has been taken away from them. They have no interest, they're not owners, they're equivalent to shareholders in a corporation. You would never allow shareholders in a corporation to intervene in a case. They have no ownership rights. I don't want to take any more of Mr. Lamb's time unless you have.
We'll give you a little bit more. I think I have one question, at least, if Judge Glickman will permit me. So I don't suppose to speak for my colleagues, but you know, if I'm of the view that this sort of, what I see as sort of a categorical error, saying they are going to deny the motion to expand and that is not a basis for prejudice, if I think that requires a remand, are you of the view that the trial court in the first instance needs to consider all the factors anew? Or since you're saying that essentially these factors lead inexorably in one conclusion, that we should give the court guidance on how we think each of the factors should be resolved?
Well, right now we have a different judge this docket is assigned to, so I don't know if the court would remand it specifically to Judge Rigsby or to the current judge to assign to this calendar. And I think Judge Rigsby could easily explain if it were remanded to him, which I disagree with because I think this court needs to look at what powers were given to. They're alleging that the receiver was given all these great powers to their detriment. It hasn't. It's just clarifying the original receiver order, which they should have sought to intervene then by their own standard, admitted standard that they stated 3 times. It's just substituting. All it's been done in both orders from Judge Rigsby is substituting procedurally the defunct board of the cooperative for the receiver. And they can't be heard to complain about an organization that they broke and say, it's broke, now let us intervene as mere shareholders. We get to intervene. We broke it. We didn't pay our, we didn't purchase the units for 15 years despite the laches argument. Now they want to purchase 15 years later, still want those rights. Regardless
so
of
I apologize, I said I only had one more question, but your answer actually raises another for me.
Sure.
You indicated that you thought that their interests were being represented by the cooperative.
Yes.
But when you were here in June arguing in the prior cases, I guess it's 21 CV 171 and 207, you argued that the interests of the cooperative were coterminous with the receiver. And so are those arguments inconsistent? And if so, whose interest do we think the cooperatives, which side are they on?
Not sure I exactly meant it in that context, but they're not coterminous. They are shareholders. They are equivalent to shareholders of a corporation. You don't let shareholders to intervene. And since that time,
Well, I think you may have misheard
I'm sorry.
what Judge Ali Khan was saying, if I understood her correctly.
Right, I mean, I think you said, and this I believe is at 319 of the argument, that the interests of the receiver and the cooperative were coterminous, which seems to me to mean necessarily that the interests of Mr. Di Carvalho and his colleagues is a departure from the cooperative.
Okay, and I think that is a red herring in this instance, because the interests we were talking about, the entire purpose of the cooperative, I don't know from all the appeals, I don't recall, I believe some of the judges at least were on the prior panels for that appeal. The entire purpose of the cooperative was to turn a tenants association, give the tenants who are members of that association to purchase their units. The cooperative was created as a vehicle to allow a transition. Everybody was supposed to purchase or get out. Now, almost 15 years later, there's about 18 occupants who've done neither and just want to go back to 2009. And we're well beyond that. So to answer your question, the reason why they're coterminous, the cooperative's function was to get them to get the occupants to either purchase or get out. And they were doing that, I think, until about 2017, when I guess they threw their hands up because they ran out of cash. I mean, I don't know firsthand. The inability to fund, they lost, I think, the inability to fund litigation, but they are still, Mr. Rome opposed, is still active in the case and vigorously opposing the motion for leave to appoint a receiver. He vigorously opposed the motion, the first motion to appoint the receiver. I said the current motion is to foreclose, but he vigorously opposed the motion to appoint the receiver and asked that the case be dismissed. I don't know how that's ineffective counsel and how somebody else should be substituted.
Well, it sounds like the issue comes down to whether, not one of interest, but whether the current request is for the receiver to have simply the same powers and authority as the co-op, or whether the current request is for the receiver to have greater powers than the co-op has. What is your position on that question?
It's absolutely the same. We cannot get the co-op board together and to have them vote. We don't think it's necessary, but to have them vote on whether members are in default. And the default, I think, is really only important if you're trying to terminate the membership. We're only trying to terminate the occupancy. But be that as may, it's just a procedural step to get the board together. They still, if the board had met and voted to put any member in default, each member would still, in the ensuing action to enforce the termination of either the occupancy or the membership, the member would still have the right to say that I wasn't in default. The board took an improper step.
In other words, the members could, your view is the members could still defend by saying that the co-op failed to, in effect, breached its contract with us by failing to offer us the units at the below market rate.
And absolutely.
And that and presumably that the receiver is still.
And I believe at the end of time is running. I don't know if it was the end of 2020. I believe it was the receiver, or beginning of 2021, issued increases of the occupancy charges. The primary purpose of the receivership was to increase revenue because there was none. That would have also been, I mean, they would, and the members, through letters, we haven't sought to enforce those through eviction actions or terminations, I guess we could now, but the members would have a right to still say, no, that increase is wrong for this reason, that reason, even though procedurally the court said you had the right to increase beyond 10%, we challenged the reasons for your increase, the expenses you're claiming in the increase. They still have all the same rights. They just want 2 bites at the apple, or they want to cut us off. They want to cut us off at the head, kill the head. They want certainty. They don't want the receiver's powers clarified because they had some success with the judges in the landlord-tenant branch.
But again, we come back to the same problem of this is your view of the prejudice of these factors. We have another view on the other side, and we have a judge's order saying something completely difficult to understand. And also in the matter involving the condo association, the trial judge said that the delay was substantial, but still said it wasn't fatal, ended up, denying intervention on a prejudice ground about priority of liens and whatnot. So if it's not fatal, this judge, I mean, maybe you don't want it to go back to this judge, but it seems like if this judge sees this as something where the thing you're mostly focusing on is not fatal, even if it goes against the members.
Are we talking about Judge Rigsby?
Yes, yes, sorry. Yeah, I mean, how do you reconcile that with your argument? I mean, you're focusing on something that he wasn't thinking was the important thing.
Right. As Ms. Long indicated, it could have just been a prior order they relied upon. They could have decided one component of it. I think he could have decided he was going to grant the the motion to expand the receiver's powers, and forgot.
Yeah, the
about
problem is it's the order on appeal.
Right,
It's
and then
why we're here. Yeah.
Then he worked on the motion to intervene. But I'm fairly confident Judge Rigsby would agree with me, because it was well briefed at the time how extensive the appellant's opposition had been in the landlord-tenant branch on the then powers that the receiver was exercising. And I think that this court, and certainly Judge Rigsby, can easily see that there is no loss of rights, that they certainly have tremendous rights to oppose any of these procedural decisions by the receiver in lieu of the procedural decisions that may have been made by the board. I mean, nobody would have expected the board to have lasted into 2017 or 2018. I mean,
Well, I was going to say, we've given you a little extra time there. And
A lot.
And we're responsible for your having it. But let us, I think we have your argument. Let us hear from your I shouldn't call you co-counsel, but counsel for the receiver.
thank you for your time.
Thank you, Your Honors. Konstantinos Panagopoulos for the receiver, Longate Associates. Judge Beckwith, you asked the question of what's the theory on why the Judge Rigsby said what he said, that because it's denied there's no prejudice. I think if you look at the order, which if I recall correctly starts on page 626 of the record, one of the things the judge does, and we also laid this out in our papers, is he looks at the powers that the receiver already had based on the previous receivership order. And he concluded that the powers that were being asked for here with respect to clarification were within the spirit and intent of that original order. So I think the way that this ruling makes sense is if Judge Rigsby was thinking that this doesn't really expand the receiver's powers, it clarifies those powers. And if you read it in that way, it's something that does make sense.
It definitely affected a difference, though. The ruling was what you wanted and needed.
Well, however, there are, look, my view is that that's how this happened, but I also think that the court has to consider the other factors here. And if you look at the opinion, and you can look at, I believe starting at page 633, in 634 of the joint appendix, the judge does go through prejudice to the receiver. That because the order itself was unclear, and the longer it stays that way in that state, we had inconsistent decisions below, that the receiver, the co-op, even the condominium association are all prejudiced because there's not clarity on what the receiver can and cannot do when you have these two conflicting decisions that are both up on appeal now. And that is something that was addressed, and I think that's something this court can
Let me follow
look
this
at.
through with you then. Let's assume this is correct, that this is what the judge
Okay.
was thinking. All I'm doing is clarifying the order. Did the Co-op Association argue to the judge that, no, this goes beyond the clarification?
Well, what they did, no, and the reason I can
Here's where
say.
I'm going. Let me just, so you
Sure.
understand what the thought that crossed my mind was. The tenants are coming in and saying, look, you're probably right. Maybe the judge did think all he was doing was clarifying. And the co-op didn't tell him this is going more than clarifying. Well, we think it is going more than clarifying. We think it is really expanding. And we want to be heard on that, because expanding, if it is expanding, that really is a matter of concern to us tenants. And so that's a reason to say, gee, the tenants ought to be allowed in here, because the co-op wasn't making this argument, and it's an argument they want to make, and it's not a frivolous argument.
No one made that argument below.
Well,
One
the
of the-
tenants, it sounded to me, when I asked the question earlier, it sounded to me like that's the nub of what the tenants are saying. This
they
is
wanna
not a
say.
clarification.
It's
This
what
is
they
an
want to say.
expansion.
It's what they want to say now, Your Honor. I'm sorry for
Oh, I'm
interrupting.
sorry,
My
go ahead.
apologies.
Well, you've got the gist of my thinking.
Right, and what they, under Rule 24C, they're supposed to give us, their arguments. And typically the way that's done is you submit an opposition to the motion to amend and argue why it should be denied. Here what they did was they submitted a proposed complaint, but they did not submit any opposition to the motion to amend. There aren't any arguments that are really made. All they say is, it affects our procedural rights, just generally. That's all they said. There's nothing there with respect to the arguments that Your Honor is talking about, and I think that's why the court below said and can say that this was an unopposed motion.
But let me
because-
take you to the first page of the motion. I think it's JA 402. So the proposed expansion of the receiver's authority would overrule final judgments of this court and moot out pending disputes between the receiver and the members. For this reason, the members must be permitted to intervene.
But it doesn't go through any specific issues there. And if you look at it, they really can't, because the only thing this order does is give the receiver power to clarify that the receiver has power to act in the way that the cooperative could have acted. So let's take for an example here the fact that in order for the co-op to vote to take action to remove a member, they need to have an active board. If you're in default, you can't be on the board. Everybody's in default. So the co-op itself cannot act. And what the receiver is doing is it steps into the shoes of the co-op. And here what it's doing is that it wants to act to do what the co-op can't do. Now, if the receiver is wrong, if the receiver files an action to evict and it's wrong, they can argue, you're wrong, I'm entitled to stay. You have not affected any of their substantive rights there.
So then how do you square that with the case, it's I think Jones, and I'll butcher the last name, Fondufu? It's a 2006 case from our court that says it's not enough to deny intervention because the applicants may vindicate their interests later.
Well, because, again, I think you can look at the other factors here. You can characterize this as additional prejudice to the receiver. Because if you don't allow the court to do what it did, which is to grant that motion to clarify the receiver's powers, then the receiver is potentially left with its hands tied. I mean, you have one judge who said, no, you can do this. You have the power, you have standing, and another who said, no, you can't. And so all this did was clarify those powers. And I think, I believe it was
May I ask
you.
you a question?
Sorry.
Is it being too cute to say that if, as you say, the co-op simply can't act because its board, it has no board, then they can hardly act on behalf of the tenants and represent the tenants in the litigation? They can't do much of anything.
Well, what they can do is what they've done. They did oppose the appointment of a receiver. They are involved in the case itself. What they're limited in doing is having the board vote to terminate these rights. And so that's what can't be done, and that's what the court below was clarifying. Okay, receiver, since the co-op can't do this, you can. And again, if the receiver gets it wrong, they have the opportunity to make those arguments. This doesn't, it's not a retroactive, order here. This is an order that
I mean, I'm
moves.
sympathetic to the argument that you're in a catch-22, but it seems to me that rather than have individual tenants, I guess your colleague said there were 18 of them, have to raise this in individual proceedings with the potential for conflicting judgments like we already have, having the opportunity for the interveners to make their full-throated argument here and to get one decision that'll be good for 18 separate cases is the more efficient route.
No, because they're looking at something completely different. They're looking at whether the receiver has the authority to institute these actions. That's what the court said here, not whether or not each tenant may have a very different argument. You may need 18 different cases and 18 different arguments because there are 18 different grounds for opposing either a foreclosure proceeding or an eviction proceeding or a termination proceeding. And so that's going to happen anyway. What we're talking about here is something very different.
Is it though? I mean, I think the question is whether the receiver gets this expanded or clarified power to essentially step into the shoes of the board and circumvent the board's normal process. I know that you say that the co-op board currently is not functioning because it's comprised of people who are all in default. But if you were to have had these folks intervene below and the judge would have said, I'm still expanding the receiver powers because I reject all the arguments you interveners are making, wouldn't that be to your benefit? Because then you could take that back to the Superior Court in all these eviction actions and say, hey, I have the authority to bring these proceedings.
Well, that's what the court has already done, and it has stated a couple of bases for the reason it did that. And again, the prejudice to the receiver is there. I know it may not be appropriate to answer a question with a question, but would it have been different if the court had said, okay, receiver, you have the power to act as the board for the co-op? Would have gotten to the same place, but you only have one receiver here. And the receiver was just given the power to literally stand into the shoes of the co-op, which is what one judge already thought it had, and another judge said no, and what the judge below, in this case, Judge Rigsby, clarified.
Well,
Yes.
can I ask you, just to press you a little bit on this, your characterization of his ruling that we see as self-contradictory? It's interesting the way you put it, that he's, his view is more one of clarification, and that was actually part of the motion, I think, as well. But first of all, is that the argument you were making in your brief? I can't remember which one of you was really calling this more dicta, which seems like the opposite of, clarification, which sort of goes to the heart of it. And then second, there are two different parts in the order where the judge kind of refers to this. And the first one's more general. The court will neither expand the receiver's powers nor terminate the receivership, which could fit into what you're saying. But
Right.
At the end, he says, the members will not suffer any prejudice as the impetus of this intervention is to challenge expanded powers the receiver seeks, but which this court has denied for the reasons stated above. And that word denied seems to go a little further, especially when, like 10 lines down, he says, ordered that the plaintiff's motion to amend is granted. I'm sorry, this is getting kind of picky, but I think it's an important point about what the judge actually means.
And I think what fits in there is the judge, I believe, right before that discussion, if I'm remembering it correctly, also said, look, you're still subject to the COVID restrictions. Mm-hmm. There are things that COVID says you can't, the COVID legislation says you can't do that you can, that you still can't do. So this doesn't, expand your powers there. So
It's weird to call that denied, though.
To the extent the judge thought that there was a request for that, it could be called a denial. And again, I think when you look at the analysis, when you look at the reasoning, all the reasoning is there. And I think it is important to remember that they originally, below, they were seeking 4 grounds for intervention. And 2 of them related to affirmative claims that they wanted to assert. And they submitted a proposed complaint to the court. They've abandoned those on appeal. There's nothing in their brief that argues with respect to those. And the only thing they've argued is we should have been allowed to intervene to oppose the expansion of the receiver's powers.
So I'm sympathetic to that argument, but I guess how do you reconcile it with the notion that once a party is permitted to intervene, essentially they're in for a penny, in for a pound, and act as a party in the litigation? Do we have the authority, and if so, can you point us to a rule or a case that says we could limit their intervention to merely opposing the motion to expand the receivership?
I don't think you need to do that, because here they didn't, the judge denied their motion to intervene to assert those affirmative claims, and they didn't appeal that, okay? So the only thing they did was they appealed the basis of the judge's decision denying their motion to oppose the amendment to clarify the receiver's orders. But below, they submitted no motion on that issue. They didn't submit anything under Rule 24C. And the co-op didn't oppose it either, so I think it was fair for the judge to call that an unopposed motion. So where you are here is you have two abandoned arguments, which I don't think they can resurrect by simply mentioning them in a footnote. And you have arguments that they did not meet their burden on below because they didn't fully and fairly tell us what their arguments were. What is their basis for opposing a receiver being able to step into the shoes of a co-op?
I mean, I think it comes from your own motion to expand, and I'm looking at JA 323. Lapis seeks to expand the receiver's powers to allow the receiver to terminate members' interests without the consent of the cooperative board or a majority of the cooperative's members. They don't think you should have that authority.
Well, but where did they say that? I mean, the court, I don't think it's fair for the court to look at what, we say in general they're looking to do. That's basically how we characterize our motion. Here's our motion, and they oppose it. Well, what are the specific arguments they're using to oppose it? Why is it inappropriate for the receiver to step into the shoes of the co-op's board? How does that violate DC law? There's no
It might and it might not. I think the question is who gets to have a seat at the table in arguing for the right decision.
But, Your Honor, this is an argument that they should have made at the time they moved to intervene, because they have to show what their interest is here and why they would be prejudiced. And with respect to the motion to oppose the expansion of the receiver's powers or the clarification of the receiver's powers, however we want to characterize that, they didn't do that below. And they had the burden of doing that.
Well, I mean, it sort of was obvious, wasn't it? I mean, they had just won in Superior Court. The receiver doesn't have the power to evict them because the receiver's powers are limited to those of the co-op, and the co-op doesn't have the power to evict them. So the judge says, well, I actually want the receiver to have the powers, have that power to evict them. Well, that's the expansion. They don't want to, and that is how they are prejudiced. This interpretation by another judge that the receiver and maybe the co-op.
Sure. I don't disagree that that's what they want, that they don't want the receiver to have those powers, because if the receiver doesn't have those powers, they get to potentially stay on forever, right? But why? Why is that wrong? I mean, they can't just simply say, nuh-uh. They can't say, no, we don't want the receiver to have these powers.
That's right. They may be wrong in their legal argument. That may be. But
they didn't make one.
I mean, even if they made it, they might have been wrong,
Well,
I suppose. But they may still have the right, it may still have been obvious enough that they have an interest at stake here that's not being argued and that they claim.
Sure. And Your Honor, I wish, there are times in my career where I wish the court may have assumed what my arguments might have been. I might have been a little bit more successful in a motion. But I believe here that they had the burden of showing that they had this either right to intervene or that the court in its discretion should permit them to intervene. And they had the burden of making arguments in support of that motion. And they can't merely say, we don't like what the court did because that hurts us. They have to tell us why that is legally inappropriate. Because, sure, if they're not paying.
Do they have to say that, put their legal argument, it's an argument about the limitations of the co-op's powers, which they've clearly made. They said, look, the co-op has, that has this contract with us. They have to do certain things in order to require it, to get to the point where they could evict us.
I don't think that's the issue below. The issue below was the receiver and whether the receiver could fully step into the co-op's shoes. And that's what they,
But it was more specific than that, wasn't it? It was so that the receiver could do something that the
Yes.
Superior Court, my fellow judges said the receiver was not allowed to do.
Yes, it
And
was-
that apparently the co-op may not be allowed to do.
yes. Well, no, the co-op could, and I think that was the issue. When you look at the cases that are on appeal below, the question is who, in one of them, is who had the authority to do this. But, Your Honor, yes, we made very specific arguments below, and they should have made very specific arguments in opposition to those arguments, and they didn't. And that's one of the things that is important to consider here is this is an issue where they bear the burden. And they bear the burden of establishing that they have the right to intervene. And what the court did here, if you look at the entire opinion, is, the court explained why they thought it was why Judge Rigsby thought it was untimely. Right? He explained it. And I do believe that the co-op and the condo association are in completely different positions here. As soon as the receiver was appointed, as soon as it winds up taking on any rights that the co-op had, they were affected. To the extent they wanted to make these claims, they should have been made years ago, not now. And if they're going to make these arguments, they should have told the court why this expansion of power or this clarification of power was wrong. What rule or law does it violate? They don't tell us. All they tell us is that, they want to oppose it. Well, that's not enough. They can't just say we want to oppose it.
Did you argue that the intervention should be denied because the motion didn't comply with 24C? Because that appears to be the argument you're making here, right? They needed to
We did in
append
our
their
brief,
opposition.
yes. Yes, that's one of the arguments we make is that, they didn't comply with 24C. They didn't make an argument here. And I think, when you look at the court's analysis below, call this an unopposed motion, and they're right, there wasn't even a draft motion that was filed on why they oppose it.
And so what do you make then of the copious federal case law that says that failure to comply with Rule 24C is not fatal to intervention?
Well, if you look at the case law in DC, we've got case law that says, look, you need to at least put people on notice. There are times when it has been excused, I agree with that, but only where the pleadings make clear exactly what the arguments are.
Right, and the argument is you want to terminate my interests, and I don't think you're allowed to do that.
No, why? I mean, the argument is not that. The argument is, we don't want you to be able to terminate our interests. There's no follow-on. We don't want you to be able to terminate our interest because it doesn't comply with DC Code section whatever. It doesn't comply with the US Constitution. It doesn't comply with DC Court of, Superior Court Civil Procedure Rule, whatever. None of that is in there. They just say, hey, we don't want you to do this because this hurts us. We might have to leave. That's not enough.
What about the fact that the judge basically accepted that? If you can interpret what Judge Rigsby wrote as being, well, you would be prejudiced if I expanded these, but you're not because I'm not doing that.
Well, I don't think that's what Judge Rigsby said. He didn't say you'd be prejudiced if I expanded. All he said was, okay, because I'm not expanding, there's no prejudice. I don't think you can take the next step. All he's saying is, okay, you take this step into the water, you're not in over your head. That doesn't tell us that if you take the next step into the water, you will be. I don't think you can go that far here. And I think, in fact, when you look at the analysis in his opinion, that you can't go that far because what Judge Rigsby really focused on was the prejudice to the receiver. The prejudice
Right, but
to
I was going to say, if you're right, that we can't know that he meant that, but we don't know what he meant, doesn't that require a remand?
No, because there's so many alternative bases on which to affirm. They didn't attach.
That he addressed?
Well, in part, yes. He certainly addressed that it was an unopposed motion. They didn't file any type of opposition or any proposed opposition. He certainly addressed the prejudice to the receiver. That's in, I believe, as I indicated, page
Sorry,
634 of the joint
I
appendix.
query whether you're putting too much weight on unopposed, because only parties or interveners can oppose motions, and here they were, person non grata. So in looking at the opposition, it seems to me that its context would suggest it's the co-op's opposition that was missing, not that there needed to be appended to the motion to intervene some sort of opposition.
Perhaps, that's not an unfair interpretation, but it doesn't change the fact that they didn't file a proposed opposition. There's nothing that
Rule 24
says.
doesn't require that necessarily as the federal courts have interpreted it.
It certainly requires at least notice of what the arguments are. That's clear. That's a shall in the rule, and they didn't do that. You look at their pleadings below. They don't tell us why this is wrong. They just say, hey, we want a seat at the table. To do what? Why? And that was their burden to establish below, and they didn't do that. And this court can clearly look at the record below and say, okay, sorry, you didn't do that. And
Do the judge's comments about, you mentioned prejudice to the original parties, the judge's comments about it being early stages of the litigation, how this case has been stagnating, how nothing's really going on, or there hasn't been orders for discovery or whatever, do those apply? Because that,
well, I think it's important to remember that we have a few different proceedings here. Okay? There's the action below where they sought, it relates to the default and the relief that has been sought so far as the appointment of a receiver, which has been stayed. And then there are the corollary proceedings that have occurred where the receiver has taken action to sell vacant units, where they're vacant, and now seeking to foreclose on some units that are vacant as well, and then seeking to take action it should be able to take to evict tenants at sufferance who aren't paying. And so I think it's important to view the fact that it's not just the one proceeding we're talking about here. And what they're moving to intervene in is this breach of contract proceeding, right? That's what they're moving to intervene in below, is this lawsuit for a breach of a loan agreement where the lender has sought the appointment of a receiver to protect the interest in the property and to protect the property itself. And the receiver has powers with respect to that. And what's their interest there? If they think the co-op isn't doing the right thing, maybe they have a claim against the co-op, but they're not a proper party to this. They haven't done anything to establish what their interest is in that piece of litigation either. I think that there are lots of fatal flaws that were argued below that they didn't have an interest. And again, they're not losing any rights in that if they believe that they have a right to possession of the premises, if they believe that they have a right to own the premises and that the co-op didn't offer that right to them, they can assert whatever substantive claims they believe they have here. And they can defend against eviction proceedings utilizing those substantive defenses. But, what we have here, frankly, is, a rearguard action where you have members of a co-op who have not complied, where the receiver has started to take some action. A court has, two different judges in a court have said, well, it's not clear what you can do. Judge Rigsby clarifies that, and they want to oppose that clarification. I mean, it makes sense. I mean, if you're arguing for your client, you want to come in and say, no, 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 at every step of the way. But again, you have to tell us why. Why are you entitled to intervene here? Why are you entitled to say, no, receiver, you can't step into the shoes of the co-op to do what the co-op can otherwise do? They didn't do that.
I think we have your argument.
Thank you.
Thank you.
I appreciate the extra time.
Ms. Long?
I would just like to make one brief point, just to further clarify. The motion that the members intervened to oppose was titled a motion to clarify and expand. There's no question that what that motion was seeking was an expansion of the receiver's power, and it was an expansion that went beyond the bounds of what the cooperative itself could do. It took away procedural rights that the members were guaranteed under the bylaws, and those rights are important because it guarantees a certain.
How did it take away receiver's rights? It authorized the receiver to pursue an eviction action. Is that it?
It went beyond that. It gave the receiver the power to terminate members without there being meetings or votes of the board, which are required under the bylaws. So it takes away the right to a deliberative process before folks are terminated, giving them an opportunity to.
So it didn't actually terminate the tenant's rights, but it authorized the receiver to do so. Do you take that as a legal judgment that the receiver has the right to terminate, or simply has the right to proceed to try to terminate?
To clarify, I don't think the expanded receivership power automatically terminated anyone's rights. It gave the receiver the power to terminate memberships.
And if the receiver tries to exercise that power, are you saying that the tenants would not have any ability to oppose it?
I think that if they tried to enforce that in subsequent eviction actions, it would be very difficult for the members in subsequent actions to attack the discretionary and equitable decision that the court is making on the receivership order here, and that it might, they would certainly.
So you are interpreting the receivership order here as a binding interpretation by the trial judge, by Judge Rigsby, to as to what the powers of the receiver to terminate are.
I don't think the members would concede that it would be binding on them if they are not permitted to intervene, but I think it is true that it would be undeniably very persuasive that other judges may find it binding.
What does that mean, it would be very persuasive? And I mean, the judge presumably is going to say, well, I have to do what the law says. I read the contract, I read the bylaws and so on and so forth, and I have to decide this as a matter of law. Does the receiver have the right to terminate these people or not? Is that something that Judge Rigsby has decided or not?
So with the expanded receivership power, it is purporting to give them authority to do
See,
something.
if the tenants aren't there, the tenants could argue that, well, we can't be, res judicata and collateral estoppel can't bind us on this. We have the right to oppose this, and we want an independent judgment of the trial court. Whereas if the tenants are allowed to intervene, I suppose, and if they then lose, then their hands might well be tied, I suppose. Is that true?
Yes, I think that if the members are permitted to intervene, and they are parties, there certainly could be preclusive effects.
What if some tenants intervene and others don't?
So to clarify, they're members, and I can't speak to other members. There are other members that we're not representing here. I am not sure exactly what the status of their memberships is.
I mean, is it fair to say maybe we've been misinterpreting if I understood correctly, and maybe I didn't, is it fair to say that when we say the judge has this inexplicable statement in his order, we've simply been misinterpreting it? What the statement really means simply that the judge is denying that he expanded the receiver's powers. In his view, all he's done is clarified them.
I don't think that's accurate. I don't think there's anything in what the order says to suggest that. And looking at the text of the expanded receivership order, it is clear that the actual effect is that their powers were expanded and expanded beyond what the co-op itself could do. So it is not the receiver purporting to stand in the shoes of the.
Read to me, if you would, in the receivership order, exactly what it is that you think. It's not simply a clarification. Yes, I really meant for the receiver to have, in my previous order, for the receiver to have the power to go in and evict. But what it is that actually constitutes a legal expansion of the receiver's power beyond that of the co-op association.
So on page 641 of the joint appendix, it says ordered that receiver is authorized to terminate any member's right to occupancy and/or any member's membership interest without the co-op board and/or the majority of co-op members commencing termination procedures without a vote for expulsion by the co-op board and/or the majority of co-op members, and without authorization or approval by the co-op, co-op board, and/or co-op members, and/or without a determination by the co-op board, or the co-op members that a particular member is in default. And so that is giving the receiver power to terminate in a way that the co-op itself could not do. And though that taking away of procedural rights is something that the member should at least be given the opportunity to have a seat at the table when that decision is made.
And do you agree that if you're permitted to intervene and ultimately you lose and the receivership is expanded, that you would be bound by that in subsequent eviction proceedings? Or would you be able to have a second bite at the apple?
I believe it may be the case that the members that are made parties, they could be bound by decisions in this case.
And what was the basis, if I may ask, of Judge Rigsby's ruling that he could expand the powers of the receiver in that way?
To be honest,
See, that's more than simply saying to his fellow judges on the Superior Court, yeah, I really meant to give the receiver this power to go in and proceed with the eviction. This is a statement of, it seems like, expansion of the receiver's powers. What was the legal basis for the judge's ruling in that regard?
I don't think there's any indication that the judge below grappled with any opposing arguments. I think it just says that he found good cause to grant the motion, and it may have been the case that it was not framed to him as an expansion beyond what the co-op could do, but that is in fact what it was.
And the co-op association did not oppose? Is that what you said earlier?
That's correct. The co-op did not oppose the motion to expand.
Mr. Papadopoulos has argued that, okay, you told the judge you wanted to get in, you have this desire to be in, here's why. But you didn't tell the judge, give the judge any reason why you should be able to prevail on that claim. How do you respond to that?
I don't think that that's accurate. I think the member's motion below, it was clear why they were moving to intervene, that this was an expansion beyond what the co-op itself could do. The members clearly complied with Rule 24C. They provided a pleading as required. The rule requires notice of any claim or defense, and their opposition to the motion to expand does not really, that particular issue doesn't lend itself to a complaint or answer, but they made clear what their reason was, and it's that it would be unlawful to expand the receiver's power in this way. That's supported by the many cases cited in opposing parties' briefs that make clear that receivers at most stand in the shoes of the entity in receivership. They don't have the power to affect existing rights, and that's what this expanded power seeks to do. And the members made clear that that was their reason below.
Now, it's interesting, somebody mentioned that, Judge, that this matter is no longer before Judge Rigsby in the Superior Court. I would have assumed that if we were to remand, it would go back, it would not go back to Judge Rigsby, it would go to whatever judge now has this. Do you disagree with that?
That would be my assumption as well, that it would go to the existing judge. I will admit that I have not seen that in this exact scenario in practice before, but that would be my assumption. If there are no further questions, I just reiterate that the members request that their motion, the denial of the motion to intervene, be reversed with instructions that they're permitted to intervene, and that this court also vacate the expanded receivership order.
One concern I have is the timeliness. I just want to ask you about this, the timeliness of this attempt to intervene. When the receiver was originally appointed, it was clear, I think, maybe I'm wrong, it was clear, I think, that the goal here was to enable the receiver, among other things, to evict the tenants. You would think that the tenants would have sought to have intervened at that time and not wait 2 years and let all this stuff get litigated, especially when it's very clear that the co-op association is handicapped in its own abilities, financially and other ways. And yet the tenants failed to do that. And now they come in, and after all this has gone by, and lots of money has been wasted on litigation and all the rest, the tenants come in and say, well, we'd like to be in this and be heard. It's not obvious to me that it would be an abuse of discretion for the judge to say, look, there's too much water under the bridge here. We're not going to let you come in at this time. Parties have been adequately litigating this for 2 years, and this is too late. How do you really respond to that? How do you argue that it would be an absolute that the law is so clear, that it is so clear that the tenants should be allowed to come in now, that we can exercise our discretion to say it, and say, well, the judge would not have discretion to go the other route?
The first thing I'd like to clarify is that there has not really been much litigated in this case. It has been going on for years, but the parties, I believe 5 or 6 times, just continually consented to stays. And so this case has not really been litigated on the merits below. The receiver was appointed, and the case then stagnated for a very long period of time, including at the time that the motion to intervene was filed. So as the judge did below correctly analyze with respect to the condo association's motion, this case is in its infancy, and therefore there's not prejudice to the existing parties.
It is hard to square what he said about the condo association. I grant you with that.
Yes, and so, but even putting that aside, here it is undeniable that the motion to expand gives the members to intervene at the time that they moved, and they moved very quickly once that became apparent. And as was mentioned before, even if the court were to feel that they should have moved earlier, the case law is clear that that can be overcome if there's no prejudice to the existing parties, which is true here. And the judge below, in analyzing the condo association's motion.
Mr. Papadopoulos was arguing that there's prejudice to the receiver, and I don't know if we really probed that in argument earlier, but does prejudice to the receiver count?
Sorry, I missed the last word.
Does prejudice to the receiver count? In other words, the receiver technically is not a party, right? It's the receiver. But, although he's acted like a party in all respects, I suppose. But even if
OSPWEST,
I don't know how to pronounce
believe.
it actually, OSPWEST?
OSPWEST, I believe.
Even if OSPWEST has not made a showing of prejudice, would prejudice to the receiver be a relevant consideration?
I don't know how there could be prejudice to the receiver, who is meant to be a neutral agent of the court, but even if there could be, the receiver itself filed opposition and a brief. Neither the receiver nor the lender has shown that there is prejudice, just that they don't want there to be opposition to what they want to do is not sufficient prejudice to deny intervention when it's clear the members have interest that would be impaired.
Okay. Well, counsel, thank you. The case is submitted, and
Thank
we
you.
appreciate your efforts. We will call the next case on the calendar, NEWMARK Group Incorporated versus AVISON Young.
Morning, Your Honors. May it please the Court. Seth Horvath of Nixon Peabody for the plaintiffs and appellants, NEWMARK Group and G&E Real Estate and G&E Acquisition. Your Honors, with the Court's permission, I'd like to reserve 4 minutes of my time for some rebuttal at the end, given the nature of the issues in the case and the way the issues were presented. The case arises from AVISON Young's misappropriation of information and clients and deals from Grubb & Ellis Company that was NEWMARK's predecessor in interest. NEWMARK purchased the assets of Grubb & Ellis out of the Grubb & Ellis bankruptcy proceeding. The Superior Court ignored substantial factual issues raised by NEWMARK on all of its claims. In fact, the court inverted the summary judgment standard by resolving disputed factual issues in AY's favor. The court also entered summary judgment on NEWMARK's trade secret misappropriation claim sua sponte on a basis that wasn't briefed by the parties. Therefore, the court's entry of summary judgment was improper. NEWMARK has presented 7 issues for the court's review. The common core for 5 of those issues is, in fact, the Superior Court's decision to ignore triable issues of fact. The other 2 issues relate to the court's abuse of discretion regarding NEWMARK's request for a forensic inspection and the sanction that was imposed in connection with denying that request.
May I ask you a procedural question that's puzzled me a little? When there was a motion filed for summary judgment, the motion, I take it, was supported by a statement of material facts not in genuine dispute. Did the plaintiffs file an opposing statement of material facts in dispute, in other words, responding to that statement? I had the impression from what I read, and I didn't go through all 30 volumes of the appendix, so you'll forgive me, that the plaintiffs did not file such a response. And if so, what is the consequence of that, do you think?
Your Honor, that's not actually correct. The plaintiffs did file a line-by-line response to the statement of facts that was submitted by the defendants. In addition, because the defendant's statement of facts was very narrowly drawn, at the end of their line-by-line response to the defendant's statement, the plaintiffs also tendered additional facts that, in the plaintiff's view, are not in dispute in this matter, and plaintiffs documented those facts with voluminous deposition testimony and exhibits. So the submission that plaintiffs made responded to the defendant's submission and submitted additional facts on the back end for the court's benefit, so the court could understand the particulars of the evidence that the plaintiff believes warranted denying summary judgment.
And where does Rule 56B2 allow you to file a separate statement of undisputed facts as opposed to just limiting it to disputing the facts that your counterpart has put into evidence?
Your Honor, in Rule 56B2B, the language is that the responsive statement has to correspond to the extent possible to the statement that's tendered by the movement. And so the plaintiffs did submit a statement that corresponded to the extent possible, in that the plaintiffs articulated a response to every single alleged undisputed fact that the defendants put forward. However, there were so many other facts in the case germane to summary judgment that weren't addressed in the defendant's statement that the plaintiffs had to submit additional information for the court's context. The plaintiffs could have submitted all of those facts in response to one of the particular paragraphs, had they so chosen. They just broke it into a separate part of the same document for the court's benefit and reference. Now, incidentally, those additional facts that the plaintiffs tendered were never responded to by the defendants. So the plaintiffs generated a record.
It seems a little odd because conceptually, the notion should simply be either the statement of facts provided by the defendants was sufficient to require summary judgment or not, or to entitle them to summary judgment or not. And one would think that one would not, that the plaintiff's response here would be to simply show why that statement was either disputed or otherwise insufficient, but not to go on with a whole 50 pages of, here's some additional facts, Judge, we'd like you to know, without linking them in some way to a dispute over explaining a dispute with regard to some of the facts in the movements.
And, Your Honor, I would submit that the responsive statements that the plaintiff submitted were in fact sufficient to defeat summary judgment, but the manner in which the defendant's facts were drawn disregarded certain pertinent facts about the restrictive covenants at issue in the case, about the nature of the manner in which information was transferred from Grubb & Ellis to Avison Young with Avison Young's knowledge in violation of the restrictive covenants. The additional facts also provided information about the particular transactions that were misappropriated by Avison Young from Grubb & Ellis. So it was necessary to provide additional factual context and detail to address what was a narrowly drawn statement by the defendants.
So, I mean, you're a lawyer at a big firm. I'm sure you file lots of motions for summary judgment. Is this typical? Because this is the first time I've seen something like this.
Your Honor, I've in several other jurisdictions, depending on the local rules, submitted similar components to a response to a statement of facts. And I think it's important for the court to understand this wasn't a supplemental statement or a separate statement. This statement of facts was incorporated into the responsive statement that was submitted in accordance with the rules. And it did, in fact, follow the letter of Rule 56B2B in that it corresponded to the extent possible with the facts that were drawn out by the defendants. If the defendant's view of this rule were taken to its logical conclusion, a movement on summary judgment could portray the narrowest possible version of the facts at issue and prevent the respondent from bringing any additional information to bear so that the court can properly understand the factual context of the case.
It seems to me the way to do that would be, I dispute point one of their undisputed material facts, because here are all the facts that put that into dispute. It seems to me quite different for you to say you get to have your own set of undisputed facts. Perhaps if you had cross-moved for summary judgment, that would be in play. But it just seems very odd to me that rather than disputing the facts put on by the movement, which is what Rule 56 contemplates, you get to sort of have this frolic and detour with your own undisputed facts.
Your Honor, the issue was not that we were submitting our own statement of facts. I mean, the facts in the additional statement are in fact responsive to the contentions that the defendants put forward in their statement of facts. However, there was so much volume omitted from the factual context of the case in the initial statement submitted by the defendants that we felt compelled to provide the additional factual narrative for the court to understand the claims at issue, which are tortious interference with contract, tortious interference with business expectancies, trade secret misappropriation, and a civil conspiracy claim that's an umbrella for some of the allegations in the other claims. So that was how it came about that we submitted the evidence to the court regarding the additional facts. And there were several problems with the court's summary judgment order. With respect to the trade secret claim in particular, as we've set forth in the briefs, the court ruled on the trade secret claim on a basis that wasn't briefed by the parties. Trade secret misappropriation, as the court is familiar with, involves three elements. There's the existence of a trade secret, there's misappropriation, and there's damages. Avison Young moved for summary judgment on the second element, not on the first, but the court entered summary judgment based on the first element. So getting back to the notion of the statement of facts, the court actually ended up entering judgment on a basis that wasn't covered by the statement of facts at all, because it was a basis that wasn't put forward by the defendants in their motion. And so
that raises two questions for me. So the first is, what do you make of the fact that Avison Young, I'll call them AY, said that they opposed those facts, and then the trial court said they considered those facts? And then I guess I'll let you ask that or answer that, and then I'll get to my second question.
Your Honor, I recognize that the trial court's order stated that it reviewed all the pleadings and the exhibits and the submissions, but the trial court's order didn't actually address the factual record that we proffered with respect to the nature of the restrictive covenants, the nature of the information that was taken in violation of the restrictive covenants, the trade secrets that were placed into the record, and the specific transactions that were misappropriated by Avison Young from Grubb & Ellis in connection with the business expectancy claim. So there's a reference in the order to reviewing the information, but the order itself doesn't actually come to terms with or address the evidentiary record with any specificity. I know Your Honor had another question.
Yeah, so then that gets to, I guess, moving to a slightly separate issue, which is I would take it as odd when your counterparts did not move for summary judgment on the issue of trade secrets. They seemed to kind of assume that there were trade secrets, and then they were trying to fight their ground on misappropriation. But Did you not put into question whether there were trade secrets in the first instance? And under Thomas, doesn't that mean that it was fair game for the trial court?
Your Honor, we didn't put into question whether there were trade secrets. We simply pointed out to the Superior Court that the defendants had not moved for summary judgment on the issue of whether trade secrets existed in the case. They chose to attack whether there was a genuine issue of material facts regarding misappropriation, the second element. And there is a reference in our response brief to the notion that the existence of trade secrets was not at issue. That's generally a question of fact. There's case law to that effect. But by pointing that out, we didn't open the door for the court to then rule on an evidentiary record that never contained submissions on the point whether there were in fact trade secrets at issue in the case. And so that's how Rule 56F comes into play, and that's how we were prejudiced here by the manner in which the court ruled upon the trade secret claim.
And so if we find that there's an error with the summary judgment ruling and vacate it, doesn't that sort of put the parties back in the stage where they would file a new motion for summary judgment, where they could dispute both trade secrets and misrepresentation?
In our view, Your Honor, the defendants had the opportunity 3 years ago to move for summary judgment in this matter. They selected certain issues, they moved on those issues, and they briefed those issues. Our request would be that the summary judgment entered on the trade secret claim be reversed, in that case, that claim, rather, be reinstated for trial. The issues were briefed, the issues were put before the court. The defendants opted not to move on the existence of any trade secrets. Therefore, the time for addressing that issue below has come and gone, and
Well,
the issue should be
let's
submitted.
see, as you say, the core issue for 5 of the 7 claims on appeal is whether there was sufficient evidence to go to a jury of misappropriation, of wrongdoing on the part of some or all of the defendants, either by theft or misappropriation, or maybe there's some other torts in there. And the judge has not really, the judge concluded that he saw no such, I mean, his order, if you read his order, he said, well, I just didn't see any of that in this record. If we think, well, that can't stand because there is some evidence of that, don't we just, we don't have, I mean, we could, I suppose, because if it's a question of law, but we could say, look, it's the trial judge's burden in the first instance to sift through all this evidence and decide if it's sufficient. And we could send it back for the trial judge to, assuming the defendants want the trial judge to do it, consider whether there is sufficient evidence of misappropriation or not, right?
Your Honor, the court does have remedial authority to fashion a remand, but for purposes of case administration and efficient case management, this case has been sitting in a posture where summary judgment was filed years back, and this issue that we're now discussing wasn't part of the summary judgment briefing. So in our view, in the plaintiff's view, it would be more prudent to send the case back, acknowledging that this issue was not moved on, this issue of the existence of trade secrets, and that trade secret claim is now ripe for trial.
But that still leaves unresolved the question of whether summary judgment was appropriate on the question of misappropriation, correct? I mean, wouldn't we want to, if we agree with you that there's an error on the trade secret portion, I think we would then clear the decks and tee up the actual issue that was supposed to be before the court on summary judgment.
I think that, Your Honor, the misappropriation issue was briefed before the Superior Court, and the record on that issue is now before this court, and as we've submitted in the briefs, there's ample evidence here of trade secret misappropriation. One of the core aspects of that issue is in trade secret misappropriation under the District of Columbia Uniform Trade Secrets Act, if there's a breach of a duty or obligation with respect to the disclosure of information in violation of that duty or obligation, it supports a claim for trade secret misappropriation. And the allegations and evidence that we put forward show that Avison Young executives and Avison Young brokerage employees, all of whom were employed by Grubb & Ellis and owed fiduciary obligations and contractual obligations to Grubb & Ellis, took information in violation of those obligations. So on the misappropriation point, Your Honor, the records before the court for consideration, in our view, there's clearly a genuine issue of material fact with respect to trade secret misappropriation, given the identities of the individuals who took the information and the manner in which the information was taken.
So, I mean, be that as it may, the trial court never addressed anything related to misappropriation, correct?
That's right, Your Honor. With respect to the trade secret claim, the trial court's ruling was focused solely on whether any trade secrets had been identified in the record.
And so we have a lot of precedent saying that we're a court of review, not a first review. So could you point us to something that would allow us to get to an entire series of analyses that the trial court was simply silent on?
Your Honor, I do believe there's case law that discusses the notion of making a disposition on appeal on any grounds supported by the record below. And in this instance, there is a basis to address the misappropriation argument that the Superior Court elected not to address, based on the fact that that argument was fully briefed by the parties below. So,
okay, so then if we're allowed to affirm on any grounds supported by the record, and I'm not trying to be cute here, I'm actually just sort of puzzling through this. The parties do in their briefs join issue on the trade secrets question. So could we affirm on the trade secrets finding based on the briefing we have on appeal, or is there some sort of notice issue that precludes us from doing so because it wasn't briefed in the trial court?
the issue with respect to the trade secret finding is there wasn't a full evidentiary record presented to the trial court because of the manner in which the issue arose. There was no summary judgment briefing on the existence of trade secrets. So the submissions that the court has before it are based on legal argument of counsel. With respect to the misappropriation issue, there was an evidentiary record tendered on summary judgment because the defendants actually moved on the basis that there was no genuine issue of material fact with respect to misappropriation, and the plaintiffs rebutted that after having a full opportunity to do so, unlike with respect to the issue of existence of trade secrets.
So in your view, we could affirm the judgment below on a lack of misrepresentation, but not on a lack of trade secrets?
In our view, Your Honor, the court could reach the misappropriation issue, and it would be our view that the court should reverse on the misappropriation issue in terms of saying there's no basis to conclude that there is an absence of a question of fact on misappropriation. And then with the trade secret issue, because the time has come and gone for submitting evidence in the context of summary judgment to the court on the existence of trade secrets, that aspect of the issue should be reversed, and the court should allow that claim based on its adoption of our view on misappropriation and its rejection of their view on existence of trade secrets and the court's view to let the trade secret claim
Do you have
proceed to trial.
cases from our court? I imagine, or it just seems like from my experience here, that we would go both ways in a situation like this. Sometimes we would remand, even though what a party is asking us to decide is essentially an issue of law that has been briefed and that has a factual record supporting it. I think sometimes we would remand depending on the circumstances. Sometimes we would reach it. Suppression motions or something, affirming on a different ground or something like that. But do you have any analogous cases like, what's your best authority for why we should reach it and deal with it here in this sort of case?
Your Honor, I haven't looked at the case law regarding this court's remedial authority with specific reference to this issue. That issue wasn't briefed. I'd be happy to make a supplemental submission on that if the court would so choose. But my point to the court is, given the breadth of the court's ability to fashion a remedy here, and given the nature of the submissions that were made below, it would be most efficient to reinstate that trade secret claim because we've created an issue of material fact on misappropriation, and the defendants have effectively forfeited the ability to challenge the existence of trade secrets. And so that claim should be reinstated for trial at this point. Your Honors, I see I'm out of time. I did want to at least briefly address the tortious interference claim, if I may, and do that subject to any further questions Your Honors may have. The tortious interference with contract claim should also be reinstated. That claim, as I've alluded to, is based on AVISON Young's interference with obligations in the agreements between Grubb and Ellis and the team of brokers and staff who left Grubb for AVISON Young, and those agreements had various restrictive covenants. The Superior Court's entry of summary judgment against the plaintiffs on that claim conflicts with this court's decision in NEWMARK v. Sidwell Friends. That's a 2015 decision. It's referenced in the Superior Court's opinion in some detail. The Superior Court found that there was no evidence establishing that Avison Young disparaged Grubb and Ellis in connection with recruiting brokers to Avison Young. It also found there was no evidence establishing that Avison Young's conduct was the sole reason why the brokers left Grubb and Ellis. NEWMARK doesn't hold that providing negative information to the breaching party is the only way to tortiously interfere with the contract. It also doesn't hold that the interfering party's conduct has to be the sole reason for the breach. The standard, the intentional procurement of a breach standard, is a lot broader than that. And we've articulated the case law that supports that standard in the briefing. But in a nutshell, intentional procurement involves intentionality and impropriety, and those requirements come from the restatement second of torts, which this court often consults in evaluating tortious interference claims. And there's particular language in that restatement that addresses the notion that breaching restrictive covenants can't actually justify this type of conduct in the framework of a tortious interference claim. So for that reason, and based on that case law, we would ask the court to reverse the summary judgment that was entered on the tortious interference claim as well.
Wouldn't you need to show some sort of improper means as opposed to just kind of general competition?
Your Honor, in the context of the tortious interference with contract claim, I don't know that they use the language improper means, but the standard does in fact involve impropriety. It's actually, it's the defendant's burden on that particular point to justify its conduct. And here the defendants have justified their conduct by saying they had an interest in competition here, but an interest in competition can't justify misappropriating information in violation of legitimate restrictive covenants. So the competitive interest that the defendants have cited in support of their contentions isn't sufficient here to justify the conduct they engaged in. In addition, there's evidence to support the notion that the information in question and the transactions in question were taken without Grubb and Ellis's knowledge or consent. So there's evidence to support that those transactions and that information was stolen, which also constitutes improper conduct for purposes of tortious interference with contract.
Do you think if we reverse on trade secrets, we also have to reverse on these tort claims because perhaps the judge was like skewed, or do you think we can reverse on trade secrets but affirm on the rest of the tort claims?
Well, I think there's an important distinction between the claims and an important reason why we think the court should reverse across the board. The trade secret claim applies to information that rises to the level of a trade secret. The non-trade secret claims for tortious interference with contract, tortious interference with business expectancy, and civil conspiracy, to the extent they involve taking information, it's non-trade secret information. So there's questions of fact on all the claims, and we need the ability, should the case go to trial, to be able to contend both that the information that was misappropriated rises to the level of trade secrets, but alternatively, if not, constitutes confidential information that was protected by the restrictive covenants. So in the plaintiff's view, and as we've submitted in the briefing, we believe that the summary judgment should be reversed and vacated as to all four of the claims that were submitted. And subject to any further questions, Your Honor, I just wanted to reserve a little bit of time for rebuttal at the end.
Well, I was going to ask you, what is the significance, do you think, of the argument that's made that the team members at Grubb and Ellis who moved over to AY, in effect, I'll put this somewhat loosely, were themselves the owners of this information and material that they took over, that they had negotiated that with Grubb and Ellis, and this is not a case of misappropriating property and information belonging to Grubb and Ellis. It's a case of this team taking what was rightfully theirs.
There's a couple of very important limitations on the contractual carve-outs that Your Honor is referring to. There are some contractual provisions the defendants have relied on to argue that the information and the deals belonged to them. However, the contractual carve-outs don't apply in a situation where the defendants terminate their employment relationship without adequate justification. And there are several factual issues presented by the record whether those employment relationships were terminated with adequate justification.
Let me ask you a question about that. If I remember correctly, the justification posited for terminating the employment relationships was that the team members were not paid the, I don't know what to call it, whether it's a bonus or whatever the proper terminology is. That was pretty substantial, that they expected and were entitled to receive. What do you have to say about that?
That is part of the factual record, Your Honor. Their contention is that by not having that bonus paid, there was a violation of the agreements by Grubb and Ellis. However, in the instance of a material breach of contract under the adequate justification provisions, Grubb and Ellis was entitled to a 60-day period to attempt to cure the alleged breach. And rather than allowing that 60-day cure period to play out, the McNair team, whose conduct is at issue here, resigned and terminated their employment with Grubb within 7 days of tendering their initial notice. So the 60-day cure period that's there to allow the adequate justification to kick in wasn't met. And in addition, the McNair team, the factual record shows, later attempted to change its justification for terminating to say it was, regardless of the cure period, enough for us to point out that we hadn't been paid a bonus that we were owed. But the second provision on which they relied pertains to commission compensation, not bonus compensation. So the team tried to use the non-payment of the Grubb and Ellis bonus to justify their termination of their agreement with Grubb and Ellis, but the conduct that occurred didn't constitute adequate justification under either of the contractual provisions. And in addition, many of the breaches began to occur before that notice of termination was even tendered. So the adequate justification is one very important limitation on the applicability of the contractual carve-outs. In addition, it's very important to note, and this is something that's addressed in the facts that were submitted by the plaintiffs, one of the brokers in question, Mr. Hartman, who was involved in the misappropriation, again, as the statement of fact shows, didn't have those same contractual carve-outs in his agreement. So there's two issues of fact with respect to the termination and the circumstances under which it occurred. One is whether the adequate justification provision was properly triggered, and the second is Mr. Hartman's involvement in the misappropriation.
Thank you. Okay, you'll have a few minutes in rebuttal.
Thank you, Your Honors.
And let us hear from counsel for appellees.
May it please the Court, Nate Kritzer of Steptoe & Johnson, LLP, on behalf of the defendants' appellees. I just want to thank the Court for holding argument in person today. It is an enormous pleasure to be here. So I have a number of things I want to correct from the argument that counsel just gave, but I want to jump in first on counsel's assertion that the plaintiffs did not put into question whether there were trade secrets in this case in their opposition. And I know the Court doesn't favor reading from pleadings, but I just want to read exactly what they said. They said, and this appears at page 2201 of the record, "It is for a jury to decide, as a threshold matter, whether the materials at issue are a trade secret or are merely confidential information. Tribal issues involving trade secrets and confidential information pervade this case. These issues in themselves demonstrate why summary judgment is inappropriate here." So they explicitly argued there is a question of material fact as to whether there is a trade secret. And then they argue that they were prejudiced because they didn't have the opportunity to make the record on whether there is a question of material fact as to whether there is a trade secret.
Did you seize on that in your reply? I mean, it seems like you made the strategic decision to not challenge trade secrets in moving for summary judgment. And so when they came back and said, yes, there are disputes of material fact, did you say, no, there are not? Or did you say, it doesn't matter?
We did not brief that in our reply. That's correct. So we didn't seize on that in our reply below. We didn't make that point. However, The trial judge having, I mean, I don't know how it could be our burden to make a record for them. They're arguing we didn't have the opportunity to make a record. So whether we responded to it in reply or not doesn't bear on whether they had the opportunity to make a full record on whether or not they had a trade secret. So Your Honor cited to Thomas, which I think is apt on that point, where if a party raises an issue themselves and they're on notice such that there's no prejudice in granting against them, they can't later be heard to say they didn't have the opportunity to support the argument that they themselves chose to inject into the proceedings.
Well, I'm not sure I follow what you're saying. Let me explain why I'm losing you, perhaps.
Please.
The summary judgment motion says they've sued us for misappropriation of trade secrets. There's no evidence of misappropriation. Hence, we're entitled to summary judgment. The plaintiffs respond and say, well, trade secret claim has 3 elements. One of the elements is that there be trade secrets. That's for the jury. That's what you've read to me. The jury will have to decide whether there are trade secrets. But that doesn't make trade secrets in play at the summary judgment stage. That's just saying that the plaintiffs haven't, the defendant's summary judgment motion hasn't put this in issue, and it's not an issue because it's for the jury. What's at issue now is what they put in issue, which is the misappropriation claim. I don't know why I don't follow why what you've quoted can be construed as inviting the trial judge to reach the issue of whether there's evidence here of trade secrets or not, when the defendants haven't argued that there's no evidence, and the plaintiffs, in effect, agree with them and say, yes, for the jury. You see what I'm saying?
Your Honor, I understand. I guess the point that I'm trying to make, and hopefully it's getting through, is they had the opportunity to make this record. So what they're complaining about is that the judge ruled against them without them having an adequate opportunity to make a record.
Well, the judge granted summary judgment against them on an issue that both sides seem to have agreed was not before the judge on summary judgment.
So, I mean, we did not move on that basis. The plaintiffs put before the judge the question of whether there was a genuine issue of fact on trade secrets. So
But I don't hear them saying that. I hear them saying, just as what you've quoted was simply, you know, the trade secrets, like many other issues in this case, I suppose,
So, I mean,
are for the jury.
I mean, the context of that statement is it's argument number 1 in their brief. It's not in the standard of review section or some kind of, you know, innocuous part of their brief. This is their first argument. Number 1, lead argument in their brief is that summary judgment should be granted, or that summary judgment should not be granted because there are genuine issues of fact regarding trade secrets. But I also want to address, you know, the ground we did move on here was judicial estoppel.
But the reason I'm pressing you on this is
Sure.
because suppose they had said that. Well, that's clearly wrong, because even if trade secrets are clearly insufficient as a response to the summary judgment motion, because even if there are trade secrets, if there's no misappropriation, you're entitled to summary judgment. So, I mean, it does seem to me as if I'm having trouble understanding why the trial judge thought that at the summary judgment stage, the issue of whether there were or were not trade secrets was really before him in this case, when the defendants haven't denied it and the plaintiffs agreed that it's yes for the jury.
So, I mean, to be clear, we did deny the existence of trade secrets. The basis of our motion,
for summary
the
judgment.
basis of our motion for summary judgment was judicial estoppel, because our view was that that would be a more straightforward and simple way for the court to rule, as opposed to slogging through however many documents the plaintiffs put in front of the court in terms of, you know, what they submitted, 100-some exhibits. So that was the basis that we moved upon.
If we think, maybe I apologize for interrupting you here, but
Sure, no.
if we think that the trial judge erred in deciding the summary judgment question on the issue he did of trade secrets, where do you think that leaves us with regard to that claim?
Well, I think if the court does decide that, which of course we don't agree with, but if the court were to decide that, I do think that there would need to be a remand for further summary judgment proceedings. There are arguments that were not reached by the court below, including our argument for judicial estoppel, which we still believe is dispositive, and I'd like to address the responses in their reply, which are entirely inadequate under this court's precedents. So this is a claimant who says They bought trade secrets and were a bona fide trade secret purchaser of trade secrets from a debtor who said in their own filings they have no trade secrets.
So are you
that's a
saying there
problem.
were arguments you made in your summary judgment motion? This is what I wanted to clarify. Are you saying there are arguments that you presented to the judge in your motion for summary judgment that the judge simply did not reach?
Correct. There are arguments.
So those are still on the table, in effect.
Those are on the table, and we would also urge the court that this question around trade secrets that was identified by the judge is on the table. There is no reason to allow a case to go forward to a jury and spend the time involved in a jury trial where the judge has found there really are no issues on this, and the only question is whether the plaintiffs had the inadequate opportunity to make a record on summary judgment.
So then you think that if we disagree on trade secrets, we need to remand for misappropriation rather than consider it ourselves?
No, so the question posed to me was if you agreed to reverse. So I was working from that premise. I do think that the counsel just conceded that you can reach the question of trade secrets and misappropriation, and there are no trade secrets here. The documents that they have put forward emphatically are not trade secrets. A few examples. One is that they cite extensively to documents from a company called Allion, L-A-L-I-O-N. And I want to address specifically what counsel keeps referring to as a restriction of covenants in this agreement because they're being completely misconstrued. So if this is on page, the terms that pertain to what are referred to as trade secrets and work product that I want to direct the court to are found on page 1490 of the record, and this is in Mr. McNair's contract, and these terms apply to what is defined as the MM team, not just to Mr. McNair. So counsel said, oh, well, this isn't in someone else's contract. Well, this term applies to his team, which indisputably includes all these individual brokers. It states that the provisions shall not apply to you or the MM team's proprietary contact database and current clients as identified in Exhibit E here too. And that is not dependent on termination with adequate justification, which they did anyway, which I'll get to. And then if you turn to Exhibit E, 1506 of the record, client number 3 listed right there is Allian Science and Technology. So they're saying you stole these trade secrets, a large portion of them relate to that specific client. And we've addressed them all in our brief. I don't want to talk about every single one. But none of these documents rise to the level where they could be a trade secret. As a matter of law, they can't. And there's no reason for this to go to a jury.
So why didn't you move for summary judgment on that fact?
Because we believe that the judicial estoppel argument was, and we still believe, is a dead bang winner. That there's just, and it's a simpler basis to win. I mean, we're looking at this practically. Is a judge going to, prefer to rule for us on the question of the lack of trade secrets and have them put in, as the judge predicted, rent a U-Haul and put, a bunch of documents in front of the court? Or if we have a clean, simple basis based on undisputed facts in a bankruptcy proceeding, do we move on that basis? So that's why we moved on that basis at that stage.
Like your colleague, you're a sophisticated lawyer at a big firm. I mean, oftentimes people make 3 or 4 arguments in support of summary judgment. And here it seems like if you made the strategic choice to not do so, then why doesn't that error go to your detriment, such that if we disagree with the trial court on trade secrets or think that it wasn't properly before the trial court, you've essentially forfeited that issue on remand?
Well, I think the reason why not is that would be an extremely inefficient use of resources. I mean, and it's really not fair to our clients, given that we did raise valid bases to have these claims kicked out. They haven't been reached. The judge identified additional issues. Those issues should be allowed to be developed. I mean, even if the court concludes, which again we don't believe is correct, that the plaintiffs need more of an opportunity to make a record on this claim, which we believe that they failed to make a record on, then we should not be prohibited, and the court should not be prohibited from considering before trial whether any of these things actually are trade secrets.
So what if we were to remand for consideration of the misappropriation issue, which is squarely the court hasn't decided it yet?
I'm sorry?
What if we were to remand for the court to determine the misappropriation question?
What if you were to remand, for the court to determine the misappropriation? So I think that you mean to rule on the grounds that we argued in our motion, effectively?
Correct.
I think that would certainly have to be part of a remand, but again, I think it would be extremely inefficient, and particularly given the nature of the matters that are in front of the court, and that we've briefed, and that the court can see for itself what these documents really are. What are we talking about? We're talking about things like an employee handbook, or manual, as they call it. We're talking about a spreadsheet that calculates profit and loss. These things are not trade secrets. These are just documents that they put up to try to create a question of fact, but they don't. So for that reason, I don't think that that would be at all efficient to send this case back without an opportunity to consider those issues before trial.
Well, I suppose the judge would have discretion to decide whether to permit a further motion for summary judgment, raising issues that were not raised in the previous motion.
Sure, I think that's correct. If we were in that posture, which again, we believe the correct course here is to affirm. So I do want to address, I want to address any questions the court has on trade secrets, but I also want to make sure I address the tortious interference claims that counsel ended with. So if there are no further questions on trade secrets. So the first point that gets overlooked, and I think Judge Glickman hit on this clearly, is there's non-payment of a $3 million bonus. And under what circumstances is a broker team going to stay at a brokerage after it fails to pay them $3 million? Now, they're taking the position that they had to stay at that firm for 60 days without pay, and that's supposedly what the contract required of them was if we don't pay you, you have to sit around for 60 days to see if we decide to pay you. I mean, I think that would be unenforceable as against public policy, but that is not even what the contract says. At page 1544 of the appendix, it states, for purposes hereof, you shall be deemed to have adequate justification to terminate your employment with the company whenever you determine that any of the following events have occurred. It gives a list. One of those events is any failure by the company to pay any compensation to you when due in accordance with the terms of the employment agreement and the company policies. That's when they have adequate justification to do it. They're referring more generally to if there's some other breach of the letter agreement or the employment agreement, you have 60 days to cure. If they don't pay compensation, they don't have to wait around 60 days to get paid. I mean, that makes no sense. No one would agree to that, and no court should enforce such a term for someone who's working for their livelihood. So that is not the...
Is that true even if it's a bonus?
Yes, it's any compensation when due. It says any compensation when due. Under the...
Is a bonus due?
Yes, the bonus was due in January. It states in January of 2012, and that's undisputed. That's the terms of the contract. It says January 2012. Plaintiffs try to interpret that to mean January 31st, 2012. It doesn't give a date in January. But in any event, there's no dispute. They did not pay that bonus in January. So exactly how they believe they had any interest in these brokers staying with them when they are not paying them, when they had a retention bonus they did not pay and did not retain the brokers, that is not a valid basis for a claim. Nor do they point to anything Avison Young did to supposedly tortiously interfere, other than hiring a broker team, paying them compensation, and giving them the ordinary services you would get when you come to a firm, such as providing IT support. They claim that, look, you knew you were bringing documents, but it's clear from this agreement, from the language I read earlier, they have the right to bring a lot of documents with them. That does not in itself put anyone on notice that there's anything improper, nor was there anything improper.
So what do you make of your friend on the other side? He suggested that it was the burden for you to show that you did not exercise improper means, rather than their burden to show that you did.
I think we just had, our burden is to show a justification, and we did put forth evidence and clear facts showing we're a competitor of them in this region and in this line of service. So I think, under this court's precedence and under the section of the restatement that the judge cited below, that's clearly a competitive interest. I mean, we have a brokerage business. We're not tortiously interfering just because we don't like them. My client has a brokerage business that it wants to sustain and grow. And in the face of that, there has to then be some evidence of some form of malice. And there's no evidence of malice. They have conclusory assertions of quote-unquote stealing, but this all relates to the documents, with respect to these brokers that are subject to their carve-outs. So it's really not valid, and there's nothing, even in that sense. I mean, the fact that the brokers brought documents with them, if they had some, which I don't think they did, if they had some breach of contract against the brokers, they could assert that against the brokers. That doesn't mean that the subsequent employer did something with malice, such as to justify a tortious interference claim.
And do you agree that the trade secrets and the tort claims travel together, such that if we vacate on trade secrets, we also need to vacate on the tort claims?
No. I mean, there are different arguments and different allegations that relate to, and elements of proof that relate to a tortious interference claim. So, the tortious interference claims here, are subject to the elements of proof that were found insufficient below, such as actual interference of the contract, such as the defense of justification, and such as their failure to identify with any specificity the particular business opportunities they're talking about and how they were likely to close those opportunities, what role they have, what role we had, any of those facts. They don't identify those. So all of those things are independent, sufficient means to affirm the tortious interference claims. On top of that, I would note, I just want to address counsel's argument that, look, these tortious interference claims, excuse me, sorry, just one moment, are somehow bound up with the trade secret claims. I mean, I think that is a problem for them, if that's what they're asserting, because the trial judge ruled below on the motion to dismiss, which they didn't appeal, that to the extent you're alleging trade secrets in connection with a tortious interference claim, that can't stand under the UTSA and the preemption provisions that apply in the DC's enactment of the UTSA. And I want to point the court to page 49 of the record, where they allege defendants induce the individual Grubb & Ellis brokers to disclose trade secrets, among other things. So they have it right there in their complaint. They're saying to disclose trade secrets. The court said, I'm dismissing the claim to the extent you're basing it on that, because you can't have a claim on that ground. And they never appealed that. They didn't address that ruling in their appeal. They didn't appeal that. So they are not in a position to assert those claims in some kind of parallel fashion to the trade secret claims, as they've argued.
Could you address specifically the claim of procurement of breach of restrictive covenants in their contracts that survived the termination of the
Thank you, Your Honor.
relationship?
I would like the opportunity to address that. One moment. So they use the term restrictive covenants throughout the brief. They never really refer to what they're talking about, because it's a problem for them. Because, and again, turning to Mr. McNair's contract, which applies to the whole broker team. This is at page 1491 of the appendix. And it states, the restrictions against competition shall not apply to you or the MM team, again, the whole broker team, with respect to current and former clients, period. At any point, for any reason, adequate justification for termination or not. These restrictions do not apply to your team's clients. The whole argument they are making for procurement of a breach of some restrictive covenant is, oh, well, you gave them incentive to close some deals soon after you came over. Well, there's nothing wrong with that. They are permitted to do that explicitly under this term. They came to the firm with a huge book of business, a large roster of clients, again, laid out, examples of which are laid out in Exhibit E, which is page 1506 of the appendix, Exhibit E to Mr. McNair's contract. And these are clients who they are entirely permitted to continue doing business with as soon as they walk out the door. Now, on top of that, that's just with respect to their clients. In addition to that, it states again at 1491, page 1491 of the record, the restrictions against competition set forth in section 6 of the employment agreement shall not apply, my footnote, at all, this is just in toto, in the event your employment is terminated by the company without good cause or is terminated by you with adequate justification. They didn't pay them a $3 million bonus. They gave notice, they gave them time to cure. There was a notice provided, I believe on February 1st. There was no payment made. They actually had adequate justification at that moment under their agreement, under the language I read earlier. If they don't pay compensation with due, they're not required to stay. And they left. There were no restrictive covenants. None. Under the undisputed facts of this case, the language of this contract isn't disputed. The fact that they weren't paid is not disputed. They're trying to dispute adequate justification on some ground that you had to stay for 60 days and not be paid. But that's, that is not a supported argument. It makes no sense and it doesn't square with the contract. And so there is no restrictive covenant for which a breach could have been procured, nor was there any procurement of that breach. Nobody ever said, there's no evidence here anywhere that anybody said, hey, go get that client, or, we really want to hire you so you can get this, well-known Grubb & Ellis client, or anything of that nature. There's no evidence of that in the record. They just point to ordinary business terms, a commission program where the brokers will be paid a percentage of their commissions, IT support provided when they're onboarding at the brokerage, things of that nature. Nothing amounts to malice or any kind of unwarranted interference.
With regard, if I could ask you just a couple of factual questions. Does your answer about the restrictive covenant argument, I'll call it that, refer to or encompass, and I may not be using the terminology correctly, but payments, but client payments that were in the pipeline that, gee, I've forgotten the name,
Grubb and Ellis.
Grubb-
Yeah.
That's right.
So,
that they were expecting and that were instead funneled, as it were,
So-
to Avison and Young.
Your Honor, the plaintiffs have not identified any payments that were in the pipeline that were funneled. Now, what they're talking about, and I'm glad Your Honor raised this because I'd like to clarify this point. What they refer to repeatedly is this, what they call 30 deals in the pipeline document, which begins to appear
Say
at
it
30.
again, please,
They say 30 pipeline deals or 30
Yes.
deals in the pipeline. This starts at 3465 of the record. And this does not show 30 deals that Grubb and Ellis is waiting to be paid on that they're going to bring to Avison Young. That's not what it shows at all. It actually shows, on the first page, a number of deals which are considered Grubb and Ellis production, where they're showing, deals that have been closed but not paid. That is showed as Grubb and Ellis production. That's not shown as anything that's going to come to Avison Young. On the following page, you can see Avison Young production. So these are deals where there's no payment due, where there is not a transaction that has been consummated, and given that there is no restriction on competition at all for their current clients, and none at all for any clients, given the termination with adequate justification, there's no bar on them still going to those clients and saying, I moved to Avison Young, I'd love to have your business. That is ordinary competitive activity you can do unless there's some enforceable contract that prohibits it. Here, there isn't. And I do think that it's right, to the extent there's any question, which I don't think there is, to construe these restraints on trade narrowly. But, there is no contract here that prohibited these folks from continuing to do business with the clients they had at Grubb and Ellis. Now, they do point to one term. They say, you had to submit a TIP report, a transaction in progress report. So that might be something that Your Honor was thinking of when asking that question. I want to address that as well. So the term that addresses transaction in progress reports in the contracted issue is found at page 1502 of the record. And that just refers to the instances where there are fees and commissions received by the company on or after the termination date. And if the broker wants to share in those fees, they need to submit a report saying that was a transaction I worked on and I helped to work on and I want to be paid part of that. They're permitted to do that. The language pertains not to non-competition, though. It doesn't impose some kind of separate non-compete. It's just dealing with the practical situation where if a deal has closed and the brokerage is waiting to get paid, the broker will want to get paid for the work they did before they left the firm.
So it's a one-way ratchet. A broker that takes the clients gets to bring those clients to the new firm without anything going to the old firm that started the transaction. But if there are transactions that are closed after the broker has left, they get to have a cut?
That's what they agreed to with this broker. They agreed with this broker, if you leave the firm, and this is even more powerful. So they agreed to no non-compete. They said you can take your clients with you when you leave, and if you terminate with adequate justification, you can compete in any way you want. But on top of that, I want to point out, because I think what Your Honor's getting at is, well, shouldn't this broker be conducting business for the firm? If you look at page 1492 of the record, it states, this is in Mr. McNair's contract, that the provisions of paragraph 3 of Exhibit C shall not apply to the team's current and former clients. And then when you look at paragraph 3, this is the one that states, you agree to perform real estate transactions for the companies, for the company. So it's basically saying you can perform those services with any company you want. You are not prohibited when you leave from performing services for your team's clients at another brokerage because you came here with these clients, you built these relationships before you came here. And on top of that, again, I want to keep emphasizing, with adequate justification, it's not even limited to current clients. It also applies to any other clients as well.
One other factual question I wanted to ask you. Again,
Yes, Your
I may
Honor.
not get the terminology correct, but sort of the poster child for that, or one poster child, that appellants have for the theft of confidential information, if not trade secrets, has to do with sort of stealing or the claim is something like this, stealing the Grubb & Ellis platform on which all sorts of information was organized and provided and the like, and AY even helped one of the, I guess he was an employee, not a team member technically, but one of the employees go over and put it all on a memory stick and transport it back and help tell him how to do it and so forth. You know what I'm talking about.
I know the email you're talking about. I disagree with the plaintiff's characterization,
Okay.
but yes.
You know the
I know the
claim
email.
I'm talking about.
And this
What
is,
what is your explanation for that aspect of things? That sounds like, in effect, it sounds like they are saying, Grubb & Ellis has its confidential way of doing things. They have how they organize things. They have how they compile and organize the data. And we want to keep that to ourselves. And they sent an employee over to copy it all on a thumb drive or whatever it was, and bring it over to Avison and Young. That's how it sort of comes across to the reader. What is your, and at least this reader, maybe some more sophisticated readers would have.
this is, and I'm glad Your Honor asked. This is what that email chain actually shows. It shows communications between Bruce McNair and his team. It might be William Morris as well, the two leaders of the team, talking about their files, their email folders, with respect to their clients. This is not saying, oh, let's go on to Grubb & Ellis's, I don't know what they use the term platform vaguely, but this is talking about their files, the single individual broker's files. These brokers who have the right to take all of their team's work product, all of the files for their clients, and go to another firm. They negotiated for that right. Grubb & Ellis didn't pay them a $3 million bonus, and they decided to exercise that right. And there's nothing wrong with that. There's nothing wrong with Avison Young helping them to exercise rights they negotiated at the table with Grubb & Ellis to take this information. There is nothing in the world wrong with that. And that email chain does not reflect what the plaintiffs are saying, which is, oh, you're taking our platform. It's very clear, even from the context of that chain, that they're talking about documents that relate to the team. And if you look at what's in the record, the documents they claim came over from the broker team are documents that relate to their activities and their clients. So that's, that's what that evidence actually shows.
Now, let me ask you my final
Sure.
question. One concern I have is this is an extremely factual case. There is all these arguments back and forth about what the facts do or do not show. The judge grants summary judgment, and on putting aside the trade secret claim, the judge issues a somewhat general opinion that doesn't do a lot of sifting of the facts and addressing specific instances, but rather simply says, look, I just see no evidence of misappropriation. You haven't shown me anything. And that puts a tremendous burden on the appellate court, when we are confronted with an appendix that exceeds 30 volumes, to do the sifting and make sure that the judge got it right or not. And I'm wondering whether, under circumstances like that, the appropriate course is to remand for the judge to do the work. Do you have a reaction to that?
I mean, I think that's similar to what we were speaking about, or what would happen on
It is,
remand.
yeah.
If the court were to remand, again, our position is the court should affirm. If the court were to remand and give the judge below the opportunity to go into more detail in the first instance, instead of, as Your Honor is saying, putting that burden on the appellate court, I could understand why the court would view that as appropriate if it were determined to remand. Now, another thing, and Your Honor's, kind of hitting on the head another point, or at least in my mind, maybe it's just that I want to go there, but there's the judicial estoppel argument, and we believe that is an independent basis to affirm.
That's the failure to identify trade secrets as an asset in the bankruptcy.
Correct, and I do want to address.
That only applies to one of the
That applies to the trade secret
trade
claim.
secret claim only.
So, but that applies to the trade secret claim. And the points I want to make in response to what was said in opposition, there were a couple points made in reply, and since this was briefed on opposition and reply, we didn't get a responding brief. I want to respond to a couple points. First of all, they argue for the very first time that as the assignees of these claims, they don't stand in the shoes of the assignor, i.e. the debtor. We bought these claims from the debtor. That defense just applies to the debtor. It doesn't apply to us. That is incorrect as just a matter of black letter law. So we cited the In re Coastal Plains case where the Fifth Circuit found in a circumstance where there was a sale of claims or transfer of claims in a bankruptcy, the assignee did in fact stand in the shoes of the assignor. And I do want to cite to the court, if the court will take it, one additional case that makes this point. And this is the Southern District of New York's opinion in Molina versus Faust, Getz, Schenker, and Blee, 230 F sub 3D 279, Southern District 2017. It is elementary ancient law that an assignee never stands in any better position than his assignor. He is subject to all the equities and burdens which attach to the property because he receives no more and can do no more than his assignor. Now, the way that the plaintiffs try to get around that, they say, well, we were bona fide purchasers. How could they be bona fide purchasers of trade secrets from a company that said it had no trade secrets? It's like being a bona fide purchaser of a house from someone who says they don't have a house. It doesn't work. So, and also, they're not innocent in this process. This bankruptcy was filed with a motion, with a sale agreement in place and a motion to approve a sale agreement. That happened in February. These are all undisputed facts are in the record. That happened in February of 2012. The bankruptcy was filed on the 20th. There was a term sheet that was agreed to on February 17th. That's in our statement of undisputed facts. And then these schedules were filed in March. And in April, a sale was approved. So this is exactly the kind of circumstances and the sorts of facts where this court applies judicial estoppel consistent with its recent opinion in Dennis versus Jackson. And in Dennis versus Jackson, the court said, contrary to what the plaintiffs are saying here,
I wonder, I've had these judicial estoppel cases in the past occasionally. Let me sort of talk this through with you a little bit if I could. When the debtor withholds the information about an asset, trade secrets, whatever, a claim. So it often comes up with a potential claim that the debtor might have against some entity. When the debtor withholds that information in the bankruptcy proceeding, the debtor is in effect cheating the creditors and enabling itself, it hopes, to get something down the road as a result of that asset. To use the claim, to use the asset in some way, to get value for it. Mm-hmm. And so we apply judicial estoppel. We say, look, we're not going to reward that behavior. We're going to stop you from you, the debtor, in the subsequent proceeding, from taking advantage of your wrong. But the policy behind that, I wonder whether that really applies to, let's posit, a completely innocent assignee of the post-bankruptcy or in the bankruptcy of the debtor's assets. If the assignee looks through those assets and discovers, oh, there's something valuable here that you didn't mention, but you know that was then, this is now. Why is it? What is the policy for applying the usual rule that an assignee stands in the shoes of the assignor? In those circumstances, to apply judicial estoppel to the innocent. Now, I understand you have arguments that innocence doesn't apply here. I got that part. But what is the argument for saying the policy of judicial estoppel should apply to the innocent assignee?
So, I mean, if it is truly an innocent assignee, there is still a problem, and that problem is identified by this court in Dennis versus Jackson, which is that the issue is not, you know, bad conduct by any party or alliance or things like so that nature. The court explicitly stated, and I think this is a great statement of the policy, The pivotal issue is whether the disclosure created an unfair detriment to the creditors or whether it obstructed the bankruptcy system itself. The bankruptcy system itself, that's what this is about. It's about the bankruptcy system.
But the assignee, under the hypothetical I've given you, is not responsible for that obstruction of the bankruptcy proceeding in any way. And applying the judicial estoppel can't rectify it. If it could rectify it, I can understand that, but I don't think I mean, it's not like you can go back and.
So,
give the
I mean,
creditors,
it's,
the benefit of it.
I think the only case that cites on this, which I don't believe is on point, is the case that the plaintiffs cite from the Fifth Circuit where it's actually the bankruptcy trustee asserting the claim. And in that case, the trustee is found to be innocent, and the trustee is actually bringing a case to collect for the benefit of the creditors. So that's the only authority I'm aware that they've cited on this point, and I do think that's very much distinguishable
Distinguishable there because it's rectifying the matter for the creditors.
Correct. The money's going to the creditors as opposed to another party in a proceeding outside the bankruptcy court. So I do think that even in the, look, first of all, we don't believe they're innocent at all. There's no evidence that they believed, contrary to what they were being told in the bankruptcy schedules. I mean, look, it's one or the other. Either they didn't believe they were buying it, in which case they're not a bona fide purchaser, or they knew there was some trade secrets that they thought they were getting, in which case they're not innocent. I mean, it's kind of one or the other in this case. I think, the record bears out that, the bankruptcy schedules did not identify any trade secrets, so there wouldn't be a basis for a party to believe that's what they were getting in the transaction. And if there was that value in the transaction, those trade secrets should have been disclosed. And if Grubb & Ellis, who's ultimately the party whose shoes are standing at, they believe they had trade secrets, they should have disclosed that in their bankruptcy filing. If they had these millions of dollars worth of trade secrets, that should have been disclosed to creditors.
Okay.
And I know I'm well out of time, but I appreciate the court's attention and time. And again, thank the court for holding this argument in person. It reminds me why I wanted to practice law in the first place.
And Mr. Horvath, we'll give you a few minutes in rebuttal.
Thank you, Your Honor. Your Honor, I wanted to address 3 points on rebuttal. The first is that the carve-outs at issue do in fact contain an adequate justification limitation. The second is that the employment contracts in question with respect to the tortious interference with business expectancy claim give Grubb ownership of all the commissions generated by its agents. And the third is that the bankruptcy disclosures by Grubb & Ellis don't stop NEWMARK's trade secret claim. With respect to the adequate justification issue, I direct the court to 2 pages of the record where the adequate justification limitations on the carve-outs are specifically referenced. If the court looks at pages 2402 and 2392 of the record, and also for that matter 2393, it's very clear that the 2006 employment agreements prohibited the McNair team from taking Grubb's trade secrets and other confidential proprietary information, and that carve-out was limited by the adequate justification requirement. The same was true of the non-solicitation and non-competition carve-out, which indicates that the team was prohibited from soliciting exclusive Grubb clients or Grubb personnel. That carve-out was likewise subject to an adequate justification limitation. And the adequate justification exception that counsel referenced in his argument, or I should say the provision of the adequate justification contractual language, is as follows, that adequate justification exists in the instance of any failure to pay compensation to Mr. McNair or his colleagues when due in accordance with the terms of the employment agreement and company policies. When Mr. McNair tendered his adequate justification, he strategically eliminated the language about compensation in accordance with the employment agreement and company policies. The employment agreement addresses commissions. It doesn't address a one-time bonus payment. And so Mr. McNair's justification and the other team members' justification wasn't adequate under the terms of the provision. In addition, I would add for the court that there is no carve-out with respect to employee solicitation. And there's ample evidence in the record here that the McNair team consisted of several different individuals, most of whom Mr. McNair solicited in violation of the employee non-solicitation carve-out. With respect to the business expectancy point that I made, I just wanted to refer the court to the language in the agreement that specifically indicates that the commissions belong to Grubb and Ellis. So there's evidence that the commissions belonged to Grubb based on the contractual language, and there's evidence that Mr. Lipton, the managing director for Avison Young's Washington, D.C. office, knew that those commissions were coming in to Avison Young and were being paid to Avison Young, because the document that lists the deals in question came straight from Mr. Lipton's file. It was produced in the litigation. So there's a question of fact on the carve-outs with respect to the tortious interference with contract claim. There's a question of fact with respect to Avison Young's knowledge that it was obtaining those commissions with respect to the business expectancy claim. And my third point, Your Honors, as I referenced, was about the bankruptcy disclosures. The defendants are trying to attribute a disclosure that Grubb and Ellis made to the entity that purchased Grubb and Ellis's assets, and to say that that entity should be barred from pursuing its trade secret misappropriation claim. And that entity is NEWMARK. There's language in the asset purchase agreement that specifically addresses this issue. There's a schedule in the APA. It's a schedule that indicates that as part of the Grubb and Ellis bankruptcy, NEWMARK is purchasing everything unless it's specifically excluded. So NEWMARK purchased everything that was part of the bankruptcy estate, including any trade secrets, including any claims based on trade secret misappropriation, and that's set forth in Schedule 2.6b of the asset purchase agreement that governed the bankruptcy. So
Is that in the joint appendix?
it is, Your Honor. I don't know if I have a page for that, but that document was tendered to the Superior Court. And the last point that I'll make with respect to this disclosure argument is that there's an obvious exception for inadvertence and mistake in connection with judicial estoppel in the bankruptcy setting. And the defendants have argued that that exception is not met in any way, but one of the considerations that is very important in the inadvertence and mistake inquiry is whether and to what extent any omission on the schedules would be of a benefit to the party making the omission. Grubb and Ellis actually hurt itself by not making a full disclosure of its trade secrets. Not that it was obligated to do so, but Grubb would have actually increased the value of the bankruptcy estate by disclosing an itemized list of trade secrets. The law doesn't require such a disclosure, but it would have been in Grubb's interest to actually make that statement. And so to the extent there's an issue about whether judicial estoppel applies, Grubb's interest in making this purported omission has to be considered, along with the fact that NEWMARK was a bona fide purchaser of Grubb's assets, not the initial disclosor of the information. And so for the reasons that I set forth in my initial presentation and in these statements and in our briefs, we would ask the court to reverse the entry of summary judgment by the Superior Court and reinstate this case for further proceedings so it can go to trial. And subject to any further questions, thank you, Your Honors.
Thank you. Counsel, thank you both. Case is submitted. And the court's going to take a 5-minute break, and we'll resume in 5 minutes.
All rise. The school will take a short recess. Please be seated and come to order.
Okay, we're calling the third case on the calendar, Khan versus Orbis Business Intelligence. Counsel?
Good afternoon, Your Honors, and I'm pleased to be the first advocate in this courtroom to wish you a good afternoon in 2.5 years. I'm Alan Lewis. I represent the plaintiffs, and I ask to reserve 3 minutes for rebuttal. There are 3 reasons why the fee award should be reversed. The first is a failure to meaningfully apply the special circumstances limitation to the fee-shifting motion, which is where I'll begin. Also, there are Home Rule Act and First Amendment infirmities, which I hope to address as well. So Superior Court purported to apply the special circumstances limitation on the availability of fee shifting, but it did so in name only. It effectively conflated the special circumstances limitation with an impossible standard for a party resisting a fee award to meet the standard for granting the underlying motion to dismiss. To conclude that this is in fact what Judge Epstein did, all that we have to do is look at his decision, which is on page 289 of the record. He goes through his explanation for why he didn't find special circumstances. And in 3 distinct ways, he repeats his conclusion that he correctly decided the underlying motion to dismiss. I found you didn't prove actual malice. I still think you didn't prove actual malice. I don't think it's a close call that you didn't prove actual malice. And the only other things that he says, beyond reiterating his confidence in his motion to dismiss decision, is an unexplained characterization of the plaintiff's litigation tactics as aggressive. That makes his decision even worse. Not only did he fail to meaningfully apply a special circumstances standard, which is different from whether the underlying motion should have been granted in the first place, but he then provided vague reasons additional reasons for making his decision, this reference to aggressive litigation.
Well, what were you arguing were the special circumstances?
The special circumstances are that they include a number of things, some of which were part of the record to begin with, some of which were information that became part of the fee motion. Those include the report of Michael Horowitz, the Inspector General, in which he severely criticized Mr. Steele's methodology in preparing these reports. The result of a trial in the United Kingdom in which my clients brought against Orbis there, in which the court concluded that the very same statements complained of in this case were false. The plaintiffs bore the burden in the United Kingdom to prove falsity, or as they call it, inaccuracy. And the record developed in that court, which included evidence that Steele was at fault for the.
Mr. Lewis, this is an abuse of discretion standard. You put each of those reasons before Judge Epstein, and he ultimately disagreed with you on those. And so I'm failing to see where the abuse of that discretion is. It seems to me quite likely that he thinks that neither the UK report or court decision, nor the Inspector General report, nor the Senate Committee report show actual malice or point to any other special circumstance that would shift the presumption that fees should be awarded here.
Well, he said that he had considered the UK evidence and that it didn't alter his conclusion, but he provided no explanation for that.
So is your claim really more of one of failure to rule specifically or make findings?
Well, the findings that he did make speak to a different standard than the special circumstances test. The findings that he made were on the underlying motion to dismiss, you didn't prove actual malice. And he says that about 3 times. And then, making matters worse, he criticizes the plaintiffs for these aggressive litigation tactics. That's an improper basis for awarding fees.
Under Cyanon, which our brief cites at page 37, this court held a party is not to be penalized for maintaining an aggressive litigation
Is the
posture.
connection that clear? Is he saying, or is he just making these statements and then going on to the fees? Is he drawing a clear connection between that standard and his comments about the attorneys, or is it just a part of a number of statements he's making?
It's clear from the decision that Judge Epstein used that as a factor to make his fee award. He says so. The section of the decision in which he explains his reasons for not finding special circumstances is exceedingly short. It's actually half of a sentence, and yet in that half of a sentence, he does two things. I was right about actual malice, and you've used aggressive litigation tactics without even explaining what he meant by
So
that.
are you just drawing, from him saying, I was right about actual malice, you are determining that he is applying a merits standard to a fees question?
That's what he did, and he
Did he
wasn't.
say he was doing that, or it's just?
One can't read
Okay.
his decision as doing anything else. He offers no explanation for not finding special circumstances other than, I think I was right to grant the underlying motion, and you guys used
Well, that
aggressive.
may be because the evidence you were relying on, the Horowitz report, the UK trial, was really evidence showing that there was merit to the claim on the other elements of the claim. That is to say, not the malice part, but the, for example, the falsity part of a defamation claim. And in effect, he's saying, well, those really aren't special circumstances because they go to other elements of the claim. But the fact of the matter is none of them go to or establish that there was anything wrong or that there was any reason for the plaintiffs to think that they could present sufficient evidence of malice. And when you think of it in that posture, and you think, under our law, an award of attorney's fees in these circumstances to the prevailing party, to the defendant who's prevailed on the motion, is presumed and is going to be ordinarily the case. I wonder whether the judge can be faulted in saying, you just haven't shown me anything. You're just presenting more evidence that you were right about two of the elements, say, of the defamation claim, but nothing to indicate you had, reason to believe that there was malice here.
So actual malice.
Or other kinds of special circumstances that might apply.
Two points. One, in order to have special circumstances, the plaintiffs did not have to have proof of actual malice.
There could be others, right.
That's just another way of saying there are no special circumstances if I think I've correctly granted the motion, which is wrong, which is why at minimum the case has to be remanded. But
That seems incorrect to me. So it seems like in some ways you're sort of flipping the burden on its head. So in a normal case, absolutely, everyone bears their own costs unless there is some sort of reason to sanction the other party. In the SLAPP context, we have a presumption that when the SLAPP is found, then there will be fee shifting, unless you can come up with special circumstances that apply. The special circumstances you proffered below are, the UK court decision, the Inspector General decision, and the Senate committee report, which, as my colleague suggests, don't undermine the veracity of the decision that the court had issued, and you didn't put forth any other special circumstances beyond essentially saying, well, this could have been a borderline case, and so since I could have won, then essentially I don't have to pay fees.
respectfully, I disagree, and I'll show you why, with the notion that the UK decision and evidence didn't to some degree undermine the decision to grant the motion to dismiss. Judge Warby conducted a trial at which all of the three plaintiffs testified, Christopher Steele testified, and after that trial, this is how Judge Warby described the evidence. With respect to these defamatory statements, Mr. Steele knew that his source did not have direct personal knowledge of the underlying facts, but could only be relying on hearsay. He's failed to explain how that information would or could have come to the subsource by virtue of his job. It's unclear what efforts Mr. Steele made to verify this allegation, other than the one relevant internet search to which he has referred. Steele's evidence as to the single relevant internet search he undertook was unimpressive, and thus the defendants were, quote, easily able to demonstrate and obtain Mr. Steele's acceptance that a key element of this allegation was contradicted by information readily available on the internet.
So let me give you a hypothetical, because I think I'm maybe struggling a bit because the UK is outside of the United States. So let's say we have the slap determination on the merits that we have here, and then there's a similar case that you've brought in California, and you have prevailed over a slap suit there. Is that alone special circumstances that would warrant not shifting the fees to you here?
It could be, if by the time of the fee shifting decision, there's evidence that the case in which the defamation case that was dismissed was based on statements that were proven to be false, and in which it was proven that the defendant who made those statements acted with fault, even if not to the level of actual malice. Those are special circumstances. Otherwise, we are basically closing the door to defamation litigation in this district. Let me just add that the additional finding of the UK court, Mr. Steele does not say he questioned his source about it, the source who had no basis to know it, or asked the source to revert to the subsource for details. He evidently did not ask for any details of the hearsay information. All of that goes to bias and the cumulative case of actual malice that the plaintiffs could have made had they gotten Steele's deposition and had the opportunity to question him in this case like we did in the UK action. I'd like to echo...
I suppose you could say it would be a basis for a new trial motion under Rule 60B?
It might be, but we're not here today to consider that question. But
I mean, on the record before us, we don't know what to make of that finding by the UK.
But it was included in the fee-shifting record. Judge Epstein did not say he shouldn't consider it. Instead, he did, but didn't explain anything about his conclusion as to why it did not contain support for special circumstances. He reverted back to restating the standard for the granting of the underlying motion, and that is not enough. If I could echo some things that questions I heard you ask in the two previous arguments, Judge Glickman, you said that if one of the factors that the court said it relied on was something that it shouldn't have, that undermines the court's exercise of discretion, and we have to send it back. So here, Judge Epstein said he undermined on aggressive litigation tactics, an impermissible factor where in the United States, litigants are expected to present their arguments vigorously. So that itself invalidates the test that he said he used to grant fees. So we should do this.
I actually had a thought about that, and I'll be interested to hear what other counsel think about this. You know, you could imagine an alternative case where, it's hard to know what aggressive means, I grant you, where the plaintiff thinks he has reason to file suit, and then thinks better of it. And information comes to the plaintiff's attention, and the plaintiff says, "Oh, I really think I should reconsider, and I'm going to, drop this case." That might be the kind of exceptional circumstances case, special circumstances case, where one would say, well, it's not really appropriate to award fees in that case. The plaintiff pulled back. And that would be a contrast to plaintiffs who are aggressively pursuing their litigation, even when they can see that the tide is turning against them because they can't show malice, say, as an example. It doesn't seem to me necessarily inappropriate for the judge to say, I take that into consideration when I'm deciding whether whether special circumstances exist to allow the plaintiff not to have to pay fees. It's not so obviously wrong to me.
Well, when you say it's not obviously wrong, Judge Epstein actually said he considered the evidence that was adduced in the UK proceeding by Inspector General Horowitz, but he then offered no explanation whatsoever for why he didn't find special circumstances there. But we submit that the findings that the English court made, that Michael Horowitz made in his report, at the very least bring us closer to actual malice.
I have the same question, I suppose, that Judge Ali Khan asked. Another court made findings, but those findings are not before me. I don't know what really everything there is to know about that other proceeding. We're dealing with this proceeding in which findings were made and or not made, and that's what we're limited to. I wonder about this question of whether findings by the English court, how much weight they really should be given to this sort of analysis.
First of all, regardless of how much weight Judge Epstein should have given the English court findings, it's undeniable that the factors that he said he applied to his fee determination decision were not special circumstances because they were nothing more than a reiteration of his confidence in his motion to dismiss decision and an impermissible bit of criticism for aggressive litigation tactics.
So I don't see what's wrong with that, and so I apologize if I'm missing something, but essentially you came in and said the special circumstances that you got it wrong. So essentially it's like a borderline case and therefore it would be unjust to shift fees. And he says, I've looked at all of that and it doesn't prove me wrong, that you needed to show actual malice and you didn't. And so it seems like he's rejecting your argument that these other reports in UK case could affect the merits determination. And he says, I've considered them. It doesn't excuse your requirement of showing actual malice. You didn't. Ergo, this is not a questionable or borderline case. And so that can't be a special circumstance.
Right. He's rejecting the notion that anything but proving to me that the defendants acted with actual malice is a special circumstance in a defamation case. There's no support for that. It shouldn't be the law. And in any event, going back to his clear reliance on aggressive litigation techniques, in Christianberg, the Supreme Court made it very clear that that is not a permissible basis for penalizing an advocate. As the Supreme Court held, a fair adversary process presupposes both a vigorous prosecution and a vigorous defense. Look, all that the plaintiffs did here was bring a lawsuit for defamation based on statements that were false. They defended against the motion to dismiss and appealed it. Those are not particularly aggressive or impermissible litigation techniques. Nobody moved to sanction them. They did what litigants are expected to do, and it can't be a basis, even an additional basis, for shifting legal fees. Judge Epstein.
I don't read it that way. I think that's my problem. I read it as you haven't shown me a special circumstance. I can tell they litigated vigorously, they did all these things, they proved their case, they didn't show malice. Where's the special circumstance? That's what I'm looking for, and the judge is saying I haven't seen it. He's not persuaded that merely because there is evidence that the statement was false, and there's case law on this, and that the speaker was sloppy or careless or negligent. That's not enough. So I sort of keep coming back to, and indeed I was going to ask you and ask the other party, what do you think would be a special circumstance that would take that would be a defense? Because I think I can come up with some hypotheticals, but I think they really are special. It's very hard to find a case where you'd have special circumstances in the anti-SLAPP field that would justify denying a request for attorney's fees.
In a defamation case,
in the typical
special
defamation case,
circumstances
right,
should mean that if the plaintiff shows that it is plausible that the complained-of statements were false, and it's plausible that the defendant was quite irresponsible in publishing them, even if he doesn't quite meet the exacting actual malice standard to win his case, that's close enough to be a special circumstance. in a defamation case.
Ah.
Otherwise, we are essentially closing the courtroom door to activity that is protected under the First Amendment.
It
This
sounds
goes
like
to-
you're pushing or resisting some of our cases like Doe.
Not at all. I'm relying on Synanon, which made it clear that from the First Amendment perspective, you can't penalize a party with legal fees for conduct that comes within the First Amendment's protection, the petition clause. What you can do is you can have a statute that is for compensatory purposes only, which is not this statute. As you said in Mann, the purpose of the statute is to deter plaintiffs, not just to compensate defendants. So you can't have a fee-shifting statute that is both for a punitive purpose, as this statute is, and which sweeps under its rug conduct that is constitutionally protected. Judge Epstein didn't disagree that this conduct falls within the First Amendment right to petition, and it does, especially in light of the evidence that was unearthed in the UK. So to impose a special circumstances test for a defamation plaintiff who brings a constitutionally protected case under the right to petition has a lot of evidence for his case, including falsity and fault, and to punish him for bringing that case, just because he didn't win, is not faithful to the special circumstances test, and it violates the First Amendment.
So we have held that baseless litigation is not immunized by the First Amendment. And so how come the fact that this was determined to be a slap and therefore baseless, why doesn't that take this outside of the First Amendment entirely?
Well, it wasn't determined to be a slap. It wasn't determined to be completely baseless. The only basis of the motion, of the granting of the motion to dismiss, was this failure to present evidence of actual malice before the plaintiffs had a chance to get any discovery. They ultimately got it in the United Kingdom, and it adds to substantially the evidence of Steele's actual malice.
You are relying on that a lot, and it seems like you maybe need it to be like this fact out here about what happened in the UK, but your opponents devote quite a bit of time in their briefing to kind of taking it down.
So I'm not sure I fully understood the question.
They disagree with how compelling the UK proceeding was.
Well, there were various battles fought in that case, and we can agree when we read it that each side won some of the battles.
But if that's what Judge
but on the
Epstein
core,
has before him too, it's not quite the way you're presenting it as,
the battles that they lost were mostly peculiar to British legal standards. On the things that matter here, in a defamation case in the United States, where the statement's false, was the defendant at fault in publishing them. Those findings are very clearly in the plaintiff's favor after hearing from all three of them and from Mr. Steele. So again, while I disagree emphatically with the notion that we had to supply absolute proof of actual malice to defeat a fee motion, I respectfully ask you to look more closely at those findings, at what Steele did. He touted that he had great sources. It turns out his source was a guy living in Washington, D.C., who hadn't lived in Russia in decades. He knew that the information was based on hearsay. He didn't ask his source for more information about it when his internet search contradicted it. These things add to the weight of the conclusion, that he was biased, he was doing this for money, he wanted to reach a certain conclusion. The plaintiffs were targeted because of a false allegation that their business was engaged in server traffic with the Trump administration, which the Inspector General rejected. And so there really is much more substantial weight to the conclusion that Steele acted with actual malice here. It's close enough to be a special circumstance, but at the core, the The problem with the analysis is that all the court does to apply the special circumstances test is say, I was right and you were aggressive. And that can't be enough. At minimum, this case has to be remanded to Judge Epstein for him to apply a test, a special circumstances test, which is more than I was right and you were aggressive for reasons I won't even explain. Finally, I'd like to just touch on the Home Rule Act argument. Under the Home Rule Act, rules cannot be applied in Superior Court.
May I ask you a preliminary question about that? When I think of the Home Rule Act, I think of what was enacted in 1973 with a long title that I can no longer tell you from memory. But I think 11946 was actually enacted in 1970 and preceded the Home Rule Act.
Maybe it's not right to call
I'm not
it,
sure it's right to call it the Home Rule Act.
I'll accept that and
Okay.
just
I mean,
refer.
I take your point that 11946 is there and says what it says.
And the statute says if you're going to modify any of the federal rules of civil procedure, this court has to approve the modification first. One of those rules is Rule 11, under which the rule is a party gets a legal fee award only if the other side's conduct was frivolous.
I don't see that argument. So I think it has some perhaps like surface appeal, but what Rule 11 is speaking to is when conduct is sanctionable. And here, the anti-SLAPP statute is not saying that you need to engage in any kind of sanctions analysis. It's saying, as a substantive matter, once a suit is ruled to be a SLAPP, there shall be fee shifting. So just like I don't think 1988 is modifying Rule 11, I don't see how the Anti-SLAPP Act could be modifying Rule 11.
Well, it's a sanction because in Mann, this court, looking at the legislative history, correctly concluded that the purpose of the act was punitive.
It can absolutely be
deterrence.
punitive.
It's a sanction,
But
just like Rule 11 is a sanction.
But where is the motion for sanctions here? A motion for sanctions is governed by Rule 11. I don't see a motion for sanctions, I see a motion for fees.
They made a motion for fees under the Anti-SLAPP Act because the rule is different than Rule 11. It's better for the defendants. It modifies what the rule was. So this court had to first consider whether to adopt a rule in which fee shifting is done differently than it is under Federal Rule of Civil Procedure 11. Ultimately, this debate about whether the act as a whole is more procedural or substantive is a sideshow, at least as to the home rule, as to the Section 946 argument. Because under Section 946, whatever you call it, if a new rule modifies something that you do under the federal rules, it must be approved first. Now, I know that the court is also considering similar issues in the Banks versus Hoffman appeal, which is pending. And the court's decision in that case may resolve this as to the whole act. But there is no way that you can say that a rule that says you're presumptively entitled to fees doesn't modify a rule that says you only get them if the other side was frivolous.
I had not, that's funny, I had not thought of it this way. I had thought of it as there are many statutes under which the prevailing party can get fees. There's also Rule 11, which provides that the prevailing party can get a sanction which can include fees if there is the kind of misconduct that Rule 11 applies to. But this is not the Anti-SLAPP Act is not a statute that modifies Rule 11. The Anti-SLAPP Act is simply another statute that provides for the prevailing party to get fees. And Rule 54, I think it's Rule 54, is the rule that one looks to in the federal rules of civil procedure and in our counterpart rules. And there's no modification of Rule 54. That's how I've sort
So
of.
they didn't, the court didn't explicitly say it was modifying Rule 11, I'll grant you that, but we had only one rule that applied to fee shifting. It's Rule 11. To get it, the other side's conduct.
We have Rule 54, which recognizes that many statutes provide for fee shifting. And it sets out a procedure for when that happens, for how you apply for it, what information you have to give, and whatever else. there's no modification of Rule 54B here.
And that takes us back to the First Amendment problem, which is that the fee shifting here applies so broadly as to encompass litigation that is protected by the right to petition, and it does so for a punitive purpose. And it is that combination of scope and purpose of fee shifting that makes this statute in violation of the First Amendment. Look, you may be able to fix it if you send this back to the lower court with an elaboration on the special circumstances test in a way that requires more than a reiteration of "I was right" on the underlying motion and calling the plaintiffs' names. And if, as a part of that, there is more meaningful respect for the constitutional right to petition and a standard that stops short of what Judge Epstein did here, which is essentially all defendants who make anti-SLAPP motions get their fees awarded, we can see that Judge Epstein misperceived the standard from the get-go when, in the scheduling order, before he even heard from us, he told us he expected us to agree to pay their fees. So there was a test to be applied, but he came into it biased with the notion that fee shifting was almost automatic. It shouldn't be.
But aren't those the terms that Doe uses?
There's a presumption unless we can show special circumstance. There's been very little elaboration of special circumstances. That test, of course, comes from the civil rights cases, where courts frequently decide that the defendant it's often the government, has shown special circumstances because they were making sort of a plausible argument that deserved to be aired, even though they lost. I mean, this is what you have in Christiansburg. It's what we have here. So even though you lost, the fact that we want to create space for parties to take positions that are at least plausible and develop to the law and develop the facts in ways that are not frivolous, that are not bad faith, that are based on a substantial position. And when you do that, those are special circumstances. So that type of analysis in the civil rights cases ties the special circumstances test to the purpose of the statute. The purpose of the anti-SLAPP statute is to stop plaintiffs from stopping the speech of defendants. In this case, we're talking about a dossier of reports that was published on the internet that 6 billion people had read before we got to court. The problem wasn't that Steele or anybody was talking about it, it was that it had happened. So this was not really a classic SLAPP, as Judge Epstein seems to recognize. He just passes it off and says, that's not reason enough.
Well, we've specifically rejected the notion that something has to be a classic SLAPP or anti-SLAPP.
Yes.
To justify fees.
But after Doe in this court, in Mann, the court recognized the punitive and deterrent purpose of the statute. And when you combine that with the very broad reach of the fee shifting, you're in constitutional trouble. It's not fair. It shuts down nearly all defamation litigation, including defamation litigation based on provably false statements that harm their subjects. And surely, special circumstances, I reiterate, it requires more.
It doesn't shut down nearly all defamation litigation. We're only talking about litigation that satisfies or cases that meet the criteria of a SLAPP. And what the legislature is saying is, look, we're really concerned here that litigation is being used in a fashion that is really contrary to the First Amendment. And so, in order to deal with that, we're going to have some special procedures that are followed. And those procedures include saying that the losing party, that if the plaintiff is found to have filed a non-meritorious case, knowing that it was a SLAPP case, knowing that it met the criteria of that could bring it within a SLAPP, then the plaintiff is going to have to pay for the costs it imposed on the losing party.
non-meritorious in this context has to mean something more than you lost, which is the lesson of the civil rights cases. And here, Judge Epstein's application of the standard reveals he didn't think it meant anything more than that you lost. And he corrupted that further with an impermissible penalizing of the plaintiffs for simply bringing this case and appealing the dismissal. All of that is wrong. You can bring this statute at least closer to fidelity, to First Amendment principles, solve the Home Rule Act problem, and require, a genuine consideration of special circumstances that requires something more than I was right in granting the motion to dismiss by sending this back to Judge Epstein with those instructions. Respectfully.
We'll give you a few minutes in rebuttal.
Thank you.
Counsel for Orbis?
May it please the court, my name is Christina Hall-Eichhoff of Alston Bird on behalf of the defendants and appellees, Orbis Business Intelligence Limited and Christopher Steele. If I may, Your Honors, I would like to start by taking this phrase, special circumstances, out of isolation. My friend on the other side has been very adept at coining a phrase, the special circumstances test, or the special circumstances limitation, the special circumstances standard. I heard all of those in the argument. But in the full phrase of the law from which those two words are pulled, which is this court's decision in Doe v. Burke, the full phrase of that law is special circumstances that would make a fee award unjust. So it's not a special circumstances standard, it's an injustice standard. And the Superior Court applied sound discretion and settled principles of DC law in finding there was no injustice in making a presumptive fee award under the Anti-SLAPP Act to defendants for their wholly successful anti-SLAPP special motion to dismiss. Now, the standard of review here is abuse of discretion, and I think that is clear, but I want to make sure that if the court had any questions on that I address them. The entire award that is at issue and the foundation of Judge Epstein's order was DC Code Section 16-5504, which uses expressly discretionary language that has been recognized by this court as meriting an abuse of discretion review. Now, I want to address the factors that Judge Epstein identified in his opinion for rejecting the plaintiff's argument that special circumstances exist that would make a fee award unjust. And it is a mischaracterization, indeed a gross mischaracterization, to say that his opinion was, I was right and you were aggressive. Those are my findings. In fact, on page 289 of the appendix, Judge Epstein gives a litany of reasons why he was not persuaded that the arguments and submissions of plaintiffs would invoke an injustice to the award of attorney's fees. And the first factor that he identified was when plaintiffs filed this case, it was at a minimum predictable that the court would require them to prove actual malice. Plaintiffs did not, and still do not, have substantial evidence of actual malice. The reason why it was at a minimum predictable to the court that these plaintiffs would be required to show actual malice is, as the record fully was developed before Judge Epstein, these same plaintiffs brought an unsuccessful defamation claim in this district in 2005, and that case, OAO Alpha, was dismissed because of their status as limited purpose public figures and their failure to show actual malice. So it is a mischaracterization to say that Judge Epstein simply doubled down on his prior ruling, a ruling that this court, in a panel that included Judge Beckwith, affirmed in all respects. But he was saying not only was this ruling right, but you knew when you came here, you knew when you filed this suit, that you were likely to have to prove actual malice, and you did it anyway. And therefore, it is not an injustice to make you bear the costs of the fees that you required the defendants to generate.
So let's say that's all true. In that circumstance, is there any type of special circumstance that might militate against an award of fees?
So, and this gets to a question, I believe, Judge Ali Khan, that Judge Glickman had, which is what are special circumstances that may, hypothetically, render a fee award unjust? And there is actually no precedent in this court for an overcoming of the presumption of a fee award in the anti-SLAPP context by unjust special circumstances. That said, we do have the opinion of one Superior Court judge, and we cite this on page 8 of our brief in footnote 3, and that is a case from the Superior Court, Tufanian v. Shooks, which is case number 2020 SC3000003, a 2020 case in which the judge was considering a fee award and reasoned in those circumstances that there may be special circumstances because the plaintiff was pro se, and after the special motion was decided, they voluntarily dismissed their suit. And so in that case, the judge said those may be special circumstances. Now, there is one thing that cannot be unjust special circumstances, and that is a borderline case. Because that's exactly what was presented to this court in Doe v. Burke, when the judge below at the Superior Court had said, well, I think that there was a reasonable basis here, and this isn't a classic SLAPP, and I think that there was, sort of good reason. And this court reversed that court and said, we are not looking at motive or frivolity or grounds. That is not enough under this statutory scheme and under this court's interpretation of the fee award. That is not enough to overcome the presumption of a fee award to a successful movement. Now, I also wanted to note that as this court has acknowledged in its questioning, there's no abuse of discretion by Judge Epstein. He exercised his discretion after reviewing all of the materials that were submitted by the plaintiffs. So this is not a case where the judge said, I don't care what you have to show me, I've already made up my mind. He took pains to explain that he had, in fact, reviewed all of the materials and considered them, but distinguished them.
I think your opponent's point is he didn't really tell anybody really analyze them. He just said he looked at them.
Indeed, he did analyze them because he specifically noted that at most, those materials, in the light most favorable to the plaintiffs, at most would show perhaps negligence. But they knew coming into this court, they especially knew coming into this court, that the standard they would have to meet on defamation would be actual malice, and so none of them rise to the level of creating an injustice for them to have to bear the costs of the unsuccessful case that they initiated.
Your opponent cites Judge Epstein's mention of the fact, or inclusion of the factor, that the plaintiffs litigated aggressively. I guess I have two questions for you about that. What did he mean when he referred to litigating aggressively? And was it appropriate for him to consider that factor?
Your Honor, that is another case where my friend on the other side's paraphrasing of Judge Epstein's actual words, I think are a distortion of what was actually held. Again, at the appendix at page 289, the full phrase that includes aggressive litigation tactics is, in a full paragraph itemizing the factors that were the basis of the exercise of Judge Epstein's discretion. The phrase is, plaintiffs' aggressive litigation tactics forced defendants to incur very substantial cost to defend themselves against allegations that plaintiffs could not prove. That's not even the full sentence, that's a phrase of a much longer sentence. So I hate to even pull that phrase out of the longer sentence, but that particular phrase is, again, pulling two words out, or three words out, aggressive litigation tactics, aren't the most important words there. I would submit that carrying at least equal weight are the words that the defendants were forced to incur very substantial costs to defend themselves against allegations that plaintiffs could not prove. And so it sounds like what this court is being asked by the plaintiffs is essentially a motion for reconsideration. An argument that Judge Epstein got it wrong back in August of 2018, when this decision was made, and that the fee award is creating a new platform to try to argue the merits of the case again, or to say that the standards that they were held to in the first place were not fair.
Well, let me just get back to the, I may have another question or two for you, but
Sure.
Let me just get back to the one I asked you. Do you know, or are you able to give me an idea, what Judge Epstein was referring to when he referred to aggressive litigation tactics?
I don't know, I can't get in his mind to know what he was referring to, but I can say, as someone who is standing here 4.5 years after winning the motion to dismiss, still incurring cost, still facing opposition at every step along the way, still have gotten no compensation for the now 4-year-old successful special motion, that in the view of my clients, this litigation has been vexatious. Now, we're not saying that there's a sanction here, and we didn't move for sanctions. And the fee shifting regime under the Anti-SLAPP Act is not a sanction. Fee shifting in and of itself is compensatory, not punitive. And we cite to cases that, in our brief, that stand for that proposition.
But what do you think about your opponent's reference to Mann and how he was citing to Mann and talking about a punitive aspect?
I don't think that Mann uses the word punitive at all. It is certainly a deterrent. But the creation of an imposition of a deterrent against certain unmeritorious types of suits is not punitive. It's deterrent, and the payment of cost is compensatory, not punitive.
Are you entitled to a fee award if you prevail in this appeal, or do you still have to incur those costs?
We are entitled, and that actually, Your Honor, gets to the fees on fees. So Judge Epstein cited to many cases in sound law in this district that a party that has to litigate to recover attorney's fees can also get what are termed fees on fees, which is the fees to recover the fees in the first place. It is no surprise to my friend, Mr. Lewis, that should we prevail, there will be a fees on fees on fees motion with Judge Epstein, and indeed the court is expecting that.
I will say, there's nothing, I'm not aware that there's anything unusual in fee-shifting statutes for fees to be awarded on the work done. Normally, it isn't so extensive, but on the work done to request fees. I thought that's pretty standard, actually.
Standard that is recoverable?
Yeah, I thought so.
It is, Your Honor.
What is your reaction to the argument that, in effect, this has modified Rule 11 of the federal rules of our rules of civil procedure?
Yes, I'm happy that you brought that up because there were a few things in that regard that I wanted to address with the court. And first of all, I just want to set the table that we are not here today on any special procedure that was created by the Anti-SLAPP Act. The order at issue before this court on appeal is an order that was rendered in response to a simple motion for attorney's fees under the Superior Court Rules of Civil Procedure 54D2B2, which is identical to the Federal Rules of Civil Procedure and creates no conflict whatsoever with the, under the Section 11496. Now, the argument that the conflict giving rise to what has been termed the Home Rule Act challenge is actually Rule 11, I heard for the first time today. That was not in any of the briefing below. That's not in the appellate briefing. The argument that that is the conflict is new. But as Your Honor, Judge Glickman noted, Rule 11 is not the only procedural vehicle in the Federal Rules of Civil Procedure for the recovery of attorney's fees. And in fact, the procedure that we employed in bringing this motion, which is Rule 54D, specifies that attorney's fees, a claim for attorney's fees and related non-taxable expenses must be made by motion unless the substantive law requires those fees to be proved at trial as an element of damages. And then it goes on to specifics, and it says that unless a court or unless a statute or court order provides otherwise, the motion must specify the judgment and the statute, rule, or other grounds entitling the movant to the award. And that's exactly what we did. We filed a motion for attorney's fees under Rule 54. We identified the anti-SLAPP fee shifting provision as the basis for that motion. And so this idea that there is some sort of conflict between the procedure and that would run afoul of the so-called Home Rule Act is just not present at this stage of these proceedings. Now, to the extent that plaintiffs in their briefing and to the court below attempted a wholesale challenge to the entire Home Rule Act, or sorry, to the entire Anti-SLAPP Act, that is an untimely argument that Judge Epstein found correctly to be waived. Sorry.
Now, appellant also makes a First Amendment argument that the imposition of fees in these circumstances runs afoul of the petition clause of the First Amendment. Do you want to speak to that?
Yes, Your Honor. That is a novel and sweeping challenge, not just to the fee-shifting provision in the Anti-SLAPP Act, but by plaintiff's own concession that would apply to any fee-shifting provision in any statute that has been enacted to deter certain types of litigation. The Seventh Circuit has looked at a similar challenge and found, and this is cited on page 15 of our brief, in the Premier Electric Construction Company versus National Electric Contractors
Oh, the
Association.
the
case.
Seventh
Circuit.
I thought you said second.
I'm sorry, Seventh Circuit. It's at 814 F. 2nd, 358. And in that case, there was a similar First Amendment constitutional challenge to fees being awarded to prevailing plaintiffs under the Sherman Act. And the court there held that the proposition, I'm quoting, the proposition that the First Amendment or any other part of the Constitution prohibits or even has anything to say about fee-shifting statutes in litigation seems too far-fetched to require extended analysis. And it goes on to provide some additional reasoning, which is in our brief, and I'm not going to read it for you here, but I do want to note that the key case that the plaintiffs rely on in support of this novel constitutional challenge is a Supreme Court case from 2002, BE&K Construction versus NLRB. And that's a dense opinion. It takes a while to sift through. It has to do with the National Labor Relations Board and declarations of illegality of retaliatory litigation. It takes a while. But if you skip to the last sentence, the very last sentence of the opinion is, nothing in our holding today should be read to question the validity of statutory provisions that merely authorize the imposition of attorney's fees on a losing plaintiff. Nothing in that opinion should be read to do that, and that's exactly how plaintiffs have attempted to use that opinion.
I don't think you've cited them in your brief, but aren't there a few other state cases that have upheld the constitutionality of fee shifting in the SLAP context? I think there's at least a California and perhaps Nevada case? Have you come across those?
We actually did cite a California case in our brief, Your Honor, and that is at the bottom of page 15. I don't know if I'm pronouncing this right. It's Equilon, EQUILON, Enterprises v. Consumer Cause, Inc., and that's at 29 California 4th, 53. And in that case, the court did reject an argument that a First Amendment challenge to the fee shifting of the California Anti-SLAPP Act. If you indulge me for one moment for me to look through my notes and see if there's anything I might have missed, I would appreciate it. There's only one more point that I would like to make, and that is that in this case, plaintiffs are pointing to try to convince this court that there was an abuse of discretion and unjust special circumstances. The plaintiffs point to an extraterritorial, post-judgment, foreign proceeding from which they have selectively interpreted the results of that, and are asking this court to find that the court below erred by not giving that more importance and more weight to find an injustice here. But they go one step further, and that is to say, and in all cases, at the post-judgment fee award stage, there should be new litigation about the motives, about the basis, about the truth or falsity of all of these issues of the claim in the first place. And this is a losing plaintiff. And they are expressly asking this court to do that. And that proposal not only violates the law here that was established in Doe, but the very policy of the Anti-SLAPP Act, which is to bring cases that will not succeed on the merits to a speedy end. And here we are 4.5 years later, and it has not been very speedy. Thank you.
If I may ask you, what how should the United Kingdom, maybe that's a better way to put it, how should the court have considered, or how should we consider the United Kingdom decision in this analysis?
Judge Epstein said it was not irrelevant. I would say, I think it is irrelevant. I would say it shouldn't be considered at all because it is an unconstitutional forum. It is parallel litigation, same parties against the same defendants under a Data Privacy Protection Act that was enacted by the UK.
When you say unconstitutional forum, do you just mean a non-constitutional forum?
I do mean a non-constitutional, but there are aspects of the application of this act that I do believe would certainly be unconstitutional in the United States, by virtue of the fact that, as this court has affirmed, there is no claim here against the speech at issue in the United States under First Amendment principles that include the actual malice standard for public figures.
So let me revisit the hypothetical that I asked your friend on the other side. Let's say that everything had happened here in the district as it has, but there's a separate SLAPP suit that is brought in California and is defeated, and we'll say that for purposes of this hypothetical, the DC and California SLAPP statutes are similar. I'm not actually sure. It seems to me there are two potential options here. One, you could say that subsequent suit, since it wouldn't have any preclusive effect because this was the first suit, doesn't at all countenance a special circumstance. Or you could say, well, it suggests that reasonable minds could think of things differently, so perhaps this is, a borderline case, or there is some potential kind of good faith. Which path would you choose, and do you think that Doe indicates which one we should take?
I do. I think that Doe says you would not look at that. Because, again, Doe reversed a Superior Court judge who did an analysis that concluded with a finding that the claims were reasonable, that they were in good faith, that it wasn't a classic SLAPP suit. This court in Doe has said, that's not what you're looking at. That's not the standard that we apply. I also want to point out, getting back to the policy of the Anti-SLAPP Act itself, that the hypothetical that you've described is actually not that different from what's happened here, which is they sued the same parties in multiple forums to see where they would succeed. And not just us, but they sued BuzzFeed and Fusion GPS, anyone else, lots of other people who were associated, they sued in lots of different forums. This turns the Anti-SLAPP Act on its head to encourage more litigation, to get the opportunity for potentially better outcomes, and then use those other outcomes here on a losing motion to say, well, now I don't have to pay your fees because I was successful when I sued you that other place at the same time. We cannot reward that. That is absolutely violative of the free speech principles that the DC Council and this court has recognized are paramount and were the policy behind the Anti-SLAPP Act in the first place. Thank you, Your Honors.
Thank you, counsel. Mr. Lewis, you got a few minutes in rebuttal.
Thank you. A few points. In response to my identification of the language in the opinion penalizing the defendants for aggressive litigation tactics, my opponent says, oh, that's not it. He also mentioned that they had to pay. Well, that's circular. I mean, it's always true in a fee-shifting decision that the other side has to pay. So it's not okay to penalize aggressive litigation tactics just by calling them that with fee shifting.
I don't want to suggest what Judge Epstein may have had in mind, but your friend points to another Superior Court case where the litigant was pro se, where the suit was withdrawn, and it seems to me that maybe what Judge Epstein here is noting is the absence of those factors and the fact that you were filing lots of things that did cause them to incur costs. It's not as if you kind of timidly dipped your toe in this water and then pulled back before a lot of ink was spilled.
If a party has to withdraw a lawsuit which falls within the First Amendment's petition clause in order to avoid being punished with legal fees, we're in real trouble. That can't be the limit of special circumstances. In discussing whether it's important whether this statute is punitive or compensatory, and my opponent says,
Excuse me, I apologize, I don't mean to interrupt you, but I'm not sure I understand why you say that. If a party files a lawsuit and then discovers, oh, you know what, my lawsuit is not meritorious, and I really should not pursue this, I don't think the notion that the party ought to withdraw the lawsuit puts, under those circumstances, raises a First Amendment issue.
we didn't discover that the lawsuit was not meritorious.
No,
Judge Epstein ruled that it wasn't, but everything
but I
else
thought you
that
were.
happened surrounding these litigations reinforced that the litigation was meritorious. In the lawsuit brought against Glenn Simpson and Bean in district court, the same argument was made about the plaintiffs must have understood they'd be public figures subject to the actual malice burden at the motion to dismiss stage, and Judge Leon disagreed with that. He said the OAO case, which my adversary has talked about, doesn't make them public figures for this case, and on the motion to dismiss, I am not going to saddle them with actual malice. Similarly, in the United Kingdom, they prevailed, they proved falsity, they proved false. So this is the opposite of a situation, Judge Glickman, in which the plaintiff learns that there's a lack of merit to his case. Everything that has happened since they brought it has reinforced the merit. The Inspector General's report, the Senate committee reports, the judgment in the UK action, the indictment of Steele's source, Igor Danchenko, in the Eastern District of Virginia. Steele's reputation has fallen apart. The amount of damage that he did with this dossier, collateral damage.
You know what? There's something, this is why I brought up Rule 60B earlier. There's something very bothersome to me about this notion where a defendant, or a plaintiff in this case, a plaintiff can come in and say, look, I know I had my chance to litigate before you, Judge Epstein, and I couldn't prove it, and you ruled against me, and the evidence supports your judgment. But all these other cases, I actually prevailed. My reaction, or other people who were conducting investigations, found evidence that helps me. And my reaction, maybe it's just a parochial reaction as a judge, is to say, look, we had a trial, you know, or we had whatever proceedings we had here that were appropriate. And you had your chance to put on the evidence before me. And this is what we decide this case on. And that includes the evidence, you know, includes the question of whether you're entitled to a fee award. Now, if you think you've got newly discovered evidence, there's a remedy for that. But it doesn't come now in the question, it comes through other means. And I'm a little nervous about this notion that at the fee stage, the plaintiff, having lost its summary judgment, can just bring in a lot of other stuff that wasn't before the court earlier and say, well, but consider this and consider that and consider those other things on the question of how meritorious my lawsuit really could have been. I find that very bothersome.
The fee record is always different from the record in the underlying trial or summary judgment motion. The circumstances that are relevant are the circumstances that exist at the time of the fee decision. Judge Epstein seemed to agree with that. His problem is, again, I go back to the standard that he applied, which gave no room for anything else other than confidence in his decision. The only other thing that opposing counsel adds to that is this notion that it was predictable that they'd be limited purpose public figures. But that's just another way of saying I was right, and it also wasn't predictable for the reasons I just described in terms of the outcome of that issue.
In the interest of clarification, to make sure I'm understanding this correctly, is there any, I'll call it, quote, special circumstance, unquote, that you brought to the judge's attention that he did not, in one way or another, address? I mean, he did address, for example, the...
He purported to address it in such a limited way. The way in which he addressed the evidence was, yeah, I've got to consider it, but the only way I'm going to consider it is whether you've proved actual malice. And that's not, that doesn't the the correctness of his motion to dismiss decision doesn't preclude a finding of special circumstances. But he said it did, so he didn't apply the standard, the special circumstances standard. Is that standard difficult to meet? Sure. A court still has to apply it, and it can't just go back to reiterating the standard on the underlying motion and say you're bad because you're aggressive without explaining it. That doesn't do to satisfy the special circumstances test. Finally, this notion that the statute is compensatory only because the defendant would get the money, and it's not punitive because it's compensatory, has been rejected by the U.S. Supreme Court countless times in the context of restitution. Restitution in a criminal case is surely compensatory, but in many cases, the Supreme Court has said it's also punitive. So the compensatory aspect of the fee award doesn't mean that the D.C. Council wasn't trying to deter constitutionally protected petitioning for punitive purposes, which they clearly were.
Do you equate deterrent value with punitive?
They're not far apart. We often think of deterrence as a purpose of punishment. That's why we punish. It's to deter. To say, I'm going to issue fee awards here to make you not just compensate the other side, but to suffer yourself, you'll be deterred. That's a kind of punishment, and it sends a message to others who have been defamed that if they don't win their case on a special motion to dismiss in a context of not getting any discovery and having to prove their cases to the judge's satisfaction without access to evidence, that's going to chill the exercise of First Amendment rights. Look, you can do something that solves the constitutional problem and makes the decision on fees more faithful to the special circumstances test. And at minimum, that requires sending it back to the Superior Court and saying, don't just reiterate your confidence in the correctness of your decision and call the plaintiffs aggressive without explaining what you mean by that as the basis for your decision for rejecting special circumstances. And respectfully, if you really carefully consider the content of the Inspector General's report, the content of the Senate committee reports, the content, Steele's testimony in the UK proceeding, what the judge said about him, respectfully, I disagree with Judge Epstein that wouldn't bring the plaintiffs to actual malice, which again is a cumulative burden. I mean, Steele relied on somebody who he knew didn't have a basis to know the things that Steele then passed off as coming from high-level government officials, which it didn't. That is cumulative to the evidence of his bias, of his negligence, which is part of the cumulative process by which you get to recklessness. At the very least, what you can't do is say, nothing more, I was right, you're aggressive, I'm awarding fees. That doesn't satisfy the court's obligation to apply the special circumstances test, and it especially doesn't satisfy the court's obligation to do so with fidelity to First Amendment values. Thank you.
Counsel, thank you both. The case is submitted.
All rise. This honorable court is now adjourned.